the Employment Development Department, and the Franchise Tax Board when recurring evidence of violations exist. In addition, this measure requires the Labor Commissioner to take specified actions to facilitate audits and investigations of employers when these triggers are met. This bill represents a win for all Californians. Employees cheated out of wages, benefits, and protections will gain by AB 2770, as well as the law-abiding employers competing against unethical business owners. Furthermore, California's general fund will see the benefit of billions of dollars in tax revenue that can be used to move the state forward towards our economic recovery. I ask for your aye vote. It's my pleasure to now present my colleague, Assemblymember Bill Berryhill. He'll be followed by Mr. Alan Smith, who's president of the National Plasters Council, here to support the bill. Thank you.
Thank you. Appreciate being here with my colleague, Mr. Monning. This is truly a bipartisan effort. As we all know, with the budget in this condition it is, we're constantly looking for new revenues. We have a revenue sitting out there in the underground economy that needs to be collected. We have, as the economy continues to chug along slowly, you're going to see more and more of this underground economy grow because employers feel desperate and they start doing unscrupulous things. And it's not good for the employees, and it's not good for the legitimate employer that's out there. And so this came about by the industry, the pool industry coming and talking to myself and Assemblymember Monning. And it was very obvious. We both agreed we have to get a handle on this thing. This bill seeks to do that. And with that, I will turn it over to Alan Smith.
I appreciate the opportunity to speak on this. I'm here representing my own business. I've been in business 28 years here in Southern California. I have 80 employees. I'm also representing my National Trade Association, and I've spoken with many other trade associations and many other contractors who are sharing the same problem. I really noticed it probably about 10 years ago when we were losing more and more of our jobs to contractors and unlicensed contractors that are underbidding us, and it just seems to have perpetuated over the last several years. Basically what's happening is much like you explained, they're just simply not paying payroll tax, workers' comp, and they're getting probably a 10 to 15% trade or price advantage over us. Already this year that we've tracked, I know that we've lost probably $1.5 million in contracts specifically to these guys. Many people in my trade association are on the verge of basically going out of business because they can't sustain low margins and the low prices that they have to do to compete with these guys, so they simply lose it. It's in other businesses too. It's in the restaurant business, it's in automotive, hospitality, garment, everything, and it is rolling. I have a report here that Cal Berkeley did on the, basically it talks about the workers' comp problems and the unfair disadvantage to legitimate businesses, and it states that there's $100 billion annually of underreported payroll. That's underreported. The difference is that's the people that are actually showing minimum wage on the books and paying everything after that in cash, or maybe only showing 2 or 3 people on the payroll and maybe having 10 or 20 people that are off the books. So basically it's just killing us, and we can't sustain that. That doesn't even include the straight cash pay, which might be in the 200 to 300 billion mark. It's hard to put a number on that. There's absolutely nothing going into the system at all. So I think this bill is something that would really help us. I think it's very, very pro-business. All the people I know in the construction industry that are legitimate really welcome this. They don't see it as a hindrance or as anything that they have to jump over as a hurdle. The scrutiny is certainly welcome, and I think this would be the start of something. I'm glad to see it's bipartisan, because the monies that could be collected, this could be phenomenal. So it's really pro-business for us. I appreciate it.
Thank you, Mr. Smith. And just for the record, this is item number 24, AB 2770, and then we'll come back to your first item. Are there witnesses in support? Here's a pro-business witness.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We do support responsible business, and that is partly why we have long endorsed this idea that once you identify an employer who is already violating a set of laws, the odds are very high they are violating similar laws. So if they're not paying payroll taxes, they're probably not paying workers the wages that they're owed. And it doesn't make any sense for us not to coordinate enforcement efforts among agencies, particularly in these hard budget times. This is a bill that clearly benefits business, benefits workers, benefits the state. We think it's a terrific idea. Thank you.
Mr. Chair, Phil Vermeulen, representing the engineering contractors and several other contractor associations. Strong support. I'm proud to say that Senator Leno's carrying a bill that we're co-sponsor of the Contractors Board, going after people that don't have workers' comp, that would be able to give the license board the opportunity to shut jobs down. I think this bill, coupled with our bill, will go a long way towards going after the underground economy. Thank you.
Thank you. We want to welcome Senator Leno, a responsible California business owner. There's no due bill out there, Mr. Leno.
Good morning. This is Erin Norwood on behalf of the Spa and Pool Industry Education Council. Just want to echo the statements already made, and we're in strong support. Thank you.
Thank you, Erin.
Mr. Chair, members, Cesar Diaz on behalf of the State Building Construction Trades Council, also in strong support. Thank you.
Anyone in opposition? Lobbyists for the underground economy. Show their face. All right. Any questions or comments, Mr. Leno?
I move the bill once we have a quorum.
Yes, Mr. Smith, briefly.
Also, this underground economy, especially in construction trade, is where the deadbeats or the deadbeat dads live that are escaping garnishments. This is their home. This is probably where 80 to 90% of them live in the state, is operating there. So passing this type of thing also sends a lot of scrutiny on that huge problem to help put that out. And that, I think, is probably one of the biggest parts of it.
Thank you, Mr. Smith. Thank you for your group bringing this to all of us. Thank you to the two principals here. Anything we can do to help facilitate it along, and I think this is a good first step as we've had those meetings about, in a bicameral, bipartisan way, focusing on unresponsible business owners, and all of us are supportive of responsible California business owners. So thanks.
Thank you,
Good
Mr.
beginning.
Chair. And just a short close, I just want to offer the reassurance that this bill is not intended to go after law-abiding employers who might have a technical violation or a bookkeeping error. This is to go after the people that are engaging in conscious, intentional, egregious violations of the law, fraud of this against the state of California. So we look forward to embracing business organizations, and this is for all Californians. Thank you.
Thank you both very much. So we will take this up when we have a quorum. Mr. Monning, do you want to present
Yes.
number 14, AB 2340? Thank you again, Mr. Smith. You get a gold star, perhaps as a priceless resolution from the California State Legislature in your future.
Well, thank you, Mr. Chair, and we'll proceed now to AB 2340 regarding a worker's right to use bereavement leave when a close family member dies. At some point in our lives, we all suffer the often devastating loss of a loved one or a relative. Currently, no federal or state law provides job protection for an employee who must take a leave of absence to prepare or attend the funeral services following the death of a relative. This measure addresses this protection. Specifically, AB 2340 will provide that no employer may discharge or in any way discriminate against an employee for taking up to 3 days unpaid leave within a 13-month period upon the death of a spouse, child, parent, sibling, grandparent, grandchild, or domestic partner. In addition, the bill establishes that an employer may require an employee to provide documentation of the death within a reasonable period of time after using the bereavement leave. This measure is a humane gesture. Dealing with grief and loss at the time of a loved one's death is difficult already, but when employees have to make choices between attending a funeral service and risking job loss during these challenging economic conditions, the situation becomes unbearable. For these reasons, I respectfully ask for your aye vote, and with the permission of the chair, would like to present as a witness in support Mr. Steve Pingle from the California Employment Lawyers Association.
Good morning, Mr. DeSaulnier and Senator Leno. California Employment Lawyers Association represents over 900 attorneys who exclusively represent employees in connection with enforcing their employment rights. In this case, this is an outgrowth of a bill we sponsored 2 years ago. Assemblymember Monning has described what the bill does, but let me give you a couple examples of why this bill is necessary. One of our members has a client, a potential client named Tammy Collins. This was a single mother of 5 who was intimidated into missing her father's funeral because she'd just gotten the job less than 60 days, and she was told that if she went to her father's funeral, she would not be returning to work. And she missed her father's funeral. She needed the job. She had to feed her 5 children. This is the type of harm we want to prevent. If you look at what this bill does, it takes away 2 things from the employer, I suppose. One is the right to fire an employee for being absent from work to attend their relative's funeral. The other one is the right to intimidate the employee, as in Tammy Collins' case, out of attending the funeral. We also have a potential client of one of our members who called and tried to get him to take her case after she was fired for attending a relative's funeral. He couldn't take the case because there was no remedy. This bill will give a remedy. One of the things that I believe is in your file is a letter from a doctor who specializes in thanatology, which is the study of death and grieving. Ironically, her name is Dr. Chris Kevorkian, no relation. But she offers a letter where she talks about the cost to business of grieving and why it's in business's best interests, as it is in the citizen's best interest, to have an employee with the right to attend services after their relative dies. She talks about reduced productivity, increased errors, and accidents. And I think it came up in discussions earlier this year with one of the other interests in the bill about whether public agencies, that this would affect some public agencies, for example, I think a bus company. Well, one of the things that I think is clear from Dr. Kevorkian's letter and from the evidence that we've put before you is there is just a great possibility that the person driving the truck, if they're in the midst, if their relative has died the day before, 2 days before, they're not going to be at their most effective. I don't think we want to expose the citizens to danger and the public employer to liability. So this is, to our minds, this is an idea whose time has come. It has a special meaning to me. My mother died in March, and I can tell you, I've now had my experience with those first few days, and I was not at my best. I didn't go into my office, and I would never have expected my employees to come into my office with a recent death. So we think it's an idea who's come. We strongly urge the committee to pass this Assembly Bill 2340. Thank you.
Witnesses in support.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. I think for most of us, we probably take for granted that if you lose someone really close to you in your family, of course you wouldn't return to work in the immediate following days. But for a lot of workers, they literally have to weigh things like providing for their children versus attending a funeral and having a day or two to grieve for a parent or a spouse. That's an unimaginable choice. No one should be in that position. This is unpaid leave, so it's a minimal burden on employers and certainly something that everyone experiences and everyone deserves. So we are here in support.
Mr. Chair, members, Deanna Furman on behalf of the California Nurses Association. We're also in support. Nurses are often the first ones to comfort people after they've lost family members, and we know that it's really important that people have the time they need to reflect and move on.
Mr. Chair, members of the committee, Jeremy Smith on behalf of the State Building and Construction Trades Council, also here in support. Thank you.
Mr. Chair, members, Christy Baum with the California Professional Firefighters in support.
Witnesses in opposition.
Mr. Chairman and members, Mark Burgat on behalf of the California Chamber of Commerce. Doesn't please me to have to come up here and oppose something like this. This is certainly a very laudable goal and a very important issue. However, the Chamber of Commerce is concerned, especially in times like this, when small business bankruptcies are at an all-time high and employers are really struggling in order to cover shifts that need to be covered, and making sure that everything within their business needs to continue to move smoothly so that all employees can continue to stay employed and that business can stay in business. We don't believe a private sector mandate in this area is the appropriate role of government or the correct policy approach. I firmly believe that the intention of this bill is to catch those bad actors who don't currently offer this sort of leave. We've we checked with our members. The overwhelming majority of our members offer this sort of policy. And then on top of that, this bill creates a private right of action. So if an employer was unable to give the full 3-day leave, the employee would have a private right of action. This continued private right of action has been something that the business community has been struggling with for quite some time, and we believe continues to lead to higher unemployment rates. For those reasons, we respectfully oppose.
Okay. Other witnesses in opposition?
Good morning, Mr. Chairman, Senators. Julianne Broyles here on behalf of both the California Association of Joint Powers Authority and the Associated Builders and Contractors of California, also in opposition to AB 2340. Certainly we concur with the points raised by the California Chamber, but also would like to point out our deep concern with the private right of action section of the bill. Lawsuits against businesses is the #1 reason that they close. It is a growing area. At least a quarter of all lawsuits against California businesses are employment related. It continues to grow. We don't think that adding a new reason to sue them in such a stressed economy is a good policy for the state of California to follow. Bereavement leave, as it is currently offered to by employers as a fringe benefit, is something that you do to attract and retain employees. And adding a new mandate on that area, again, is the point that the Chamber brought up, where you can provide some of the leave but not all of the leave mandated underneath AB 2340, again, is going to create problems for smaller businesses. For that reason, we're asking for a no vote.
Thank you.
So Michael Shaw, National Federation of Independent Business, also in opposition.
Thank you, Michael.
Mr. Chairman, members, John Handley with the California Independent Grocers Association, also in opposition to the mandate.
Dorothy Rothrock, California Manufacturers Association, is also opposed.
Okay. Mr. Monning, maybe you can address the private right of action issue and also, just for myself, the magic of 13 months.
Yes.
And then lastly, how do you expect to overcome the governor's veto of Senator Corbett's bill?
Great. Well, first, if members remember the last bill we presented about trying to go after the underground economy, I've been encouraged when I've heard the Chamber and other employer associations saying on polling their members, they all provide bereavement leave and would always accommodate a loyal employee at a time of distress. So I'm kind of surprised at the opposition because this goes to level the playing field by requiring employers who may not be inclined to offer that consideration to employees a required obligation to provide unpaid leave. Our bill also provides that employer, at the employer's selection, can require the employee to take accrued vacation leave or sick leave to accommodate that. They're not mandated to, but they have that election as the employer. With respect to the 13-month period, this actually inures to the benefit of both employer and employee. It allows more time to make the accommodation for a 3-day leave to find a worker who can fill in for the bereaved worker. Also, in some religions, Buddhists mark the 1-year anniversary of a passing. So it's not as big an event right after the death as it is at the 1-year anniversary. So this seeks to be culturally sensitive in adapting to different cultures' observance of a close family member's death. But I think, again, on that point of the 13 months, it allows more time to make the arrangements necessary so that the employee can participate in a family memorial, a funeral, whatever the observance may be. Your final point with respect to the private right of action, one of the problems in low-wage jobs, particularly minimum wage jobs, under-the-table jobs, is that because of the low level of compensation there's often not an incentive or the capacity of the employee to pursue their own right. You create a private right of action, and you can create a mechanism where that employee whose right has been violated, they don't just have a law on the books that protects them, they have a means to enforce the protection that that law is intended to provide. So without a private right of action, and with furlough days and restricted budgets for enforcement agencies, you might have a protection on the books that there'd be absolutely no way to enforce it. That's the importance of a private right of action, that it's not a right on paper, it's a right in reality.
Thank you, Mr. Monning. Any questions or comments from committee members? We're still waiting for a quorum. We appreciate the bill. Can't imagine not granting this kind of thing as a former employer. And it would be nice to have a discussion based on our discussions about the underground economy and focusing on irresponsible employers, maybe to have a follow-up discussion with the opponents just to get a sense of the cost of litigation, the private right of action, versus what you said, our inability to enforce some of our regulations from a regulatory standpoint just because of our physical position. So,
thank you, Mr. Chair. I appreciate your leadership on this and your offer of accommodating that conversation. I would welcome it, and I know the people that have brought this bill to us would welcome that opportunity as well. And just a final comment, I was encouraged that many of those who have voiced opposition on the bereavement bill did not voice opposition to the bill trying to improve mechanisms for going after this underground economy. So I think on that avenue, I look forward to broad collaboration. Thank you for the opportunity this morning.
And I think just we have engaged in this, and you as your former position as chair of the Assembly Labor Committee, it's an offer that we should follow up on, I think, with Assemblymember Swanson to have that discussion. Senator Ducheney has a question.
Well, I'm guessing, I guess, Mr. Monning, if you considered a couple of possible modifications, I mean, one would be to say up to 3 days, because you shouldn't sort of have a guaranteed 3 days if you don't need it, or, I mean, you know, the funeral's tomorrow and it's downtown. I'm not quite sure the 3 days. It could be up to 3 days. It could be 1 day, it could be 2 days, depending on what the circumstances are. The other is, it was the 13 months, and I appreciate your thing about the 1 year, but, you know, 6 months seems a little more, I don't know, reasonable.
I understand. If I could just respond to both of those. I think on the 13-month, we could shorten it to 6 months, but I don't know. It doesn't help those who are in a culture that the 1 year anniversary is important. With respect to the 3 days, up to 3 days, my sense is that the employee, because it's unpaid, they're going to be the first to regulate how many days they take based on they're not getting paid for those days away. But if they're making the funeral arrangements, people often have to travel to another city. We live in a culture that's very stratified. Somebody on the West Coast might have
that's where the 3 might matter, but, but not in all circumstances. And it seems like you set up a situation where somebody could, and that goes to the private right of action problem, set up I just didn't get my 3 days, and it doesn't matter whether they really went there or they cared about going there or they did any of those things. So I don't know.
Again, I understand
the concern.
There's no enforcement
from the other side.
I think the enforcement's going to come from the grieving employee. If he or she needs the 3 days for travel, they need to have that statutory protection. If it's you said if it's just across town in a neighborhood church or temple, that employee will self-regulate. I can't afford to lose 3 days of work. I'm going to take 1 day to attend the services, and I'll be back the next day.
But the problem with the private right of action then is later when they're no longer employed there, they sue for 3 days. I mean, I don't know how you, without using the administrative piece rather than directly suing.
Yeah.
I mean, because there's no enforcement from the other side available. So.
Yeah, I understand the concern.
I mean, I like the notion that you can't discriminate and not reemploy somebody because they took off for a funeral. It's sort of similar to family leave. That makes sense. But I don't know how you set up the mechanism so that it isn't just sort of, we've had so many problems with people using the legal process in a way that was not constructive on these kinds of things that I don't know how to
In addition
fix
to
that.
If you could use the microphone, and if this is a good discussion, but just want folks to be mindful
Sorry.
as we have a very busy
Well, in addition to what Assemblymember Monning said, there's also in terms of the employee's actual use of it, and particularly after or up to 13 months, the bill requires proof of death and proof of attendance at the service of the memorial too. So there's some external governance there that the employer may require the employee to produce.
Senator Leno.
I also wanted to express support for Senator Cheney's idea of this up to 3 days. I think that softens the opposition's concern about this being mandated. And not unlike the chair as an employer, I can't imagine refusing somebody. So I don't think this actually becomes much of an imposition for most businesses. As the opposition said itself, this is probably a small universe of businesses that are actually denying these kinds of requests. But I think there would be value in sitting down with the chamber folks and others who are listed in opposition to see if you could mitigate their opposition, if not get them to neutral, either by the one up to 3 days, but also consider the private right. I mean, I understand why there needs to be some recourse, otherwise it becomes an empty benefit. But out of concern for the governor's response, you might, rather than just fighting the good fight and walking right into a veto, what communications you could have with the administration along the way to see.
Well, I appreciate those comments, and the goal here is to be successful in terms of trying to provide some protection.
And the 1 year date, you could take a vacation day. So, you just got to think about some of the possibilities of people taking vacation days to somewhere in there.
I think the point from all of us is it's a good bill. It's too bad we need a bill like this. But we also, I think, are all saying, just as we want to focus on bad employers, we don't want to, in some inadvertent way, encourage bad actions by employees. So I could imagine somebody coming back as a former employer, 12 months later and saying, I didn't get my third day. I have Buddhist tendencies. I'm going to have an attorney, and we don't want that kind of behavior either. And that's as egregious as an employer saying you can't have the time off. Because
I would say that on behalf of my fellow attorneys of SELA, most of us would be reluctant to take a case where somebody's been deprived of 1 day. That would be a very difficult case.
Problems in the past have not been the folks that are in the associations.
Well, just out of response to the concerns raised by all three of you, I think I would be open, I am open to accepting up to 3 days if that helps. My expectation is that that's not going to win the support of some of the opponents. But if it does help to at least keep the channels of dialogue open, I think it shows a willingness for us to continue to work with them towards the goal of securing the governor's support as well. So
I'm good with that, but one more thought as you go forward. I mean, it's okay to keep trying to figure this out, but if you're going to do a civil action, then you're going to have to limit what you can get or something. I mean, it's almost like if it's 1 day or 2 days, at the most you can get out of it is kind of what you...
Well, one mechanism would be...
You don't even get back paid because you weren't going to get paid for those days anyway. So you're going to have to find some limitation on what it is that could be demanded, which goes back to this sort of, if you use the administrative process, finding somebody for not allowing that and you can pick a fine amount. But when you do the right of action, you're setting up a situation that claims all sorts of damages that are sort of unspecified. And if you don't cap that in some way or limit what you can ask for, you can have an attorney go represent you before some LJ.
One option would be to have a liquidated damage in there that's a function of a day's pay for each day denied or something in minimum wage.
I don't know. You have to think of something that caps it, either an administrative or if you end up in a civil thing. I mean, it really has to be not some broad, huge, where people are going to go in and ask for emotional damages because I didn't get to go to my dad's funeral. The denial of the labor right to have the day off or denial of your right to return to work because you took the day off.
Right.
Is
Well,
different than.
Maybe can I work with the chair? I'm not quite sure the process you prefer, but this does have to make its way to the Senate floor. Is there an opportunity for us to work together on this?
I do think, Mr. Monning, it's important for the bill, but it's important for what you and I both want to do
Right.
with many of the people who are opposed to the bill. It's a good bill. I think the spirit of it is that they want to support it. So you hear from all of the members of the panel that maybe we can work on you and get the proverbial win-win out of this.
Good. Well, I appreciate the attention you've afforded us this morning and for taking the time. Thank you, Mr. Chair.
Look forward to working with you.
Thank you very much.
Mr. Monning. Mr. Berryhill is next, but are you going to let Ms. Ma go? What a gentleman. So we will hear from Ms. Ma, and this is on item number 21, AB 2570. Good morning.
Good morning, Mr. Chair and members. AB 2570 creates a licensing and regulatory framework for professional employer organizations called PEOs. PEOs are entities that assist small and medium-sized businesses with a wide variety of human resource services, including unemployment tax reporting, worker benefit acquisition, and payroll payment and reporting. PEOs can provide valuable benefits to both employers and employees, including the ability for small businesses to combine purchasing power for more affordable group health plans for their employees. However, under current law, PEOs are not regulated, and as cited in the analysis, there have been instances of fraud and abuse. Under this bill, EDD can ensure that only legitimate PEOs are operating in California and vital employee information is being accurately reported to the department. A number of issues were raised in the committee analysis, and I would like to take a moment to respond. First, on the issue of sponsorship, I would like to delete the reference to the word sponsorship as it pertains to employee benefits and worker compensation plans. As cited in comment 6 of the committee analysis, I would like to accept the committee's recommendation to include the word exclusively. And as cited in comment number 4 of the committee analysis, I would like to propose that the bill clarify that workers' compensation insurance can only be offered by PEOs in compliance with rule number 4. Finally, again, in response to comment number 1 of the analysis, I would propose to reassure the committee by inserting language on page 3, line 34, that clarifies that what was always the intent of the bill, that the benefit plans offered by PEOs would only be offered as plan policyholders like other employers currently do. The analysis also raises the issue of PEO and client liability. It is my belief that the carefully negotiated language in the bill ensures that the EED has the ability to recover all unemployment and disability insurance that it is owed. First, it provides EDD with enforcement action against a PEO. If the client is at fault, EDD has enforcement authority over the client. Finally, this bill requires that PEOs post a surety bond that EDD will be able to use to obtain any UI or disability taxes that are owed. In closing, AB 27 is a response to the growing number of small businesses that use PEOs and the need to create a licensing and registration process with EDD. The bill will ensure that PEOs are remitting all taxes that are owed by their clients and that any abuse in reporting can easily be remedied with strengthened enforcement. I would like to thank organized labor, particularly Angie Way, with the California Labor Federation for their time and willingness to work with the sponsors of this legislation. Tim Tucker is here, as well as Greg Hammond, to discuss any questions that you have.
Okay. Any questions? Any other witnesses in support? We almost have a kumbaya moment, so if you want to be brief.
Mr. Chair, my name is Greg Hammond. I'm the Chief Legal Officer for TriNet Group, which is headquartered in San Leandro and is the largest professional employer organization in the state of California.
Mr. Chairman, good morning. Members of the committee, Tim Tucker. I'm with the National Association of PEOs. We believe the legislation before the committee today is a good manner to address the growing industry, as the author pointed out, and we certainly look forward to working on some additional amendments and moving this forward.
Chairman and members, John Norwood on behalf of ADP Total Source. We also support this bill. Thank you.
Thank you, John. Thank you, gentlemen.
Thank you.
If we have any questions, stay close by. Anyone else in support?
Do we have the amendments as drafted as she suggested, or they're just...
We do not.
Okay, it's just it's a response to those. Okay.
Any witnesses in support? Any witnesses in opposition? Is there a witness who is ambivalent?
Thank you, Mr. Chair and members. Angie Wei, California Labor Federation, anxiously ambivalent about this piece of legislation. We have worked on this concept with the proponents of this bill for about 7 years and believe that we have reached a piece of legislation, a vehicle that both addresses the policy goal of regulating and bringing above board these professional employer organizations while protecting the underlying statutes and case law that have governed them without regulation. I would like to officially enter into the record 2 important points that I think should be elucidated to explain our neutrality on this issue. Number 1 is on the issue of co-employment, sole employing unit or an employing unit, and I would just like to point out in the amended version on the bill on page 2 at line 4, the bill is very clear in saying that the PEO shall be deemed to be an employing unit, not the sole employing unit. This is an important clarification and amendment that the proponents have agreed to. And with the committee's indulgence, I just want to point out at the very back of the bill, we have included a broad language on page 8 at line 17 that says that there's nothing in this bill that would alter or amend any other provision of law, again preserving the relationships between PEOs and their client employers for the purposes of wage and hour, social insurance programs, and other things. So with these, what we consider to be clear protections, we are officially with no position and yet remain anxiously ambivalent about the outcome of this bill. Thank you very much.
We've created a whole new expression, anxiously ambivalent.
Thank you, Mr. Chair. And to respond to Ms. Wei, I'm willing to write a letter in the Journal to make it completely clear that this bill does not seek to make any changes to the labor law.
We would appreciate that. We appreciate staff's work and all of the parties' work working together. We just want to make sure, given that this is coming at a late part of the session, that we get it right and there are no unintended consequences to alleviate any anxiety by any ambivalent parties. Is there a motion? First of all, let's do the roll for quorum.
Senator Mark Desaulniers.
Here.
Desaulniers here. Senator Mark Weiland. Senator Denise Moreno Duchenne.
Here.
Duchenne here. Senator Dennis Hollingsworth. Senator Mark Leno.
Here.
Leno here. Senator Leland Yee.
Here.
Yee here.
Okay.
I would move the bill as amended.
Thank you. Motion by Mr. Leno. We'll look forward to finishing up the work. We'll call a roll.
Senator Desaulniers.
Aye.
Desaulniers aye. Weiland. Duchenne. Duchenne aye. Hollingsworth. Leno.
Aye.
Leno aye. Yee. Yee aye. 4 as amended.
Thank you. And before Mr. Berryhill comes up, or if you want to join us, we'll just go back and take a vote on the 2 bills we've heard, which we'll start with number 14, AB 2340 by Assemblymember Monning. That's moved by Senator Leno.
Okay.
We'll call a roll.
Was that going to be amended?
We're sending it out with the caveat that there was a lot of discussion about private right of action concerns and a commitment from Assemblymember Monning to work with the chair and the opponents to see if we can come up with acceptable amendments for the floor. Is he going on purpose?
It's going to appropriations.
Yes. So before it goes to appropriations, we'll have those discussions.
So as amended?
So the motion is to go to appropriations. I don't think it's as amended. It's to have the discussion.
Okay. Senator Desaulniers.
Aye.
Desaulniers aye. Senator Weiland. Senator Duchenne. Duchenne aye. Hollingsworth. Leno.
Aye.
Leno aye. Yee. Yee aye. 4 to approve.
Okay, and that will take us to item number 24. Again, Mr. Monning's AB.
Wait. We did 21.
AB 2770.
24.
24, AB 2770, and what this was a consensus bill about the underground economy. Moved by Senator Leno. Call a roll, please.
Senator Desaulniers.
Aye.
Desaulniers aye. Weiland. Duchenne.
Aye.
Duchenne aye. Hollingsworth. Leno.
Aye.
Leno aye. Yee. Yee aye. 4.
Okay, those all have necessary votes to move out. We will leave it open in case Mr. Hollingsworth joins us, and I'm told that Senator Weiland will not be joining us today, which will take us to Ms. Berryhill. Welcome again. We missed you. Item number 5, AB 1696.
Mr. Chair, Senators, honored to be here to present AB 1696. This bill is meant to help the families of those who have made the ultimate sacrifice to protect our community. 5 years ago, Sergeant Howie Stevenson became the first series police officer killed in the line of duty. Last month marked the 1-year anniversary when his daughter Michaela turned 18 and was cut off from receiving survivor compensation benefits, even though she had just graduated from this year from high school. You see, Michaela started school a year late, so she turned 18 before she had graduated. Actually, at the very start of her senior year, she was 18, and that was no fault of her own. For Michaela and her family, the law only allows for children of a deceased peace officer to receive benefits until they are 18, regardless of their status in school. Although we cannot fix the problem for Michaela and her family, we can make sure to remedy this for other families should they be so unfortunate to lose a parent who is killed in the line of duty. AB 1696 would simply allow children of fallen police to continue receiving benefits until 19 years of age, provided they are still attending high school, a practice that is already in use by Social Security. Opponents of the bill have noted that employers should not have to subsidize a student's poor performance should the child turn 19 in school as a result of being held back. And I agree. And if there's language that we can agree on for that, I'd be happy to accept any language in that respect. But in Michaela's situation, she was just, she was held back a year before she started kindergarten. So opponents of the bill also point out that currently police and fire personnel enjoy workmen's compensation presumptions for their work, and noted that they cannot identify a factor that justifies the children of police and fire receiving this benefits. And my response would be that this is not like a cancer presumption that a family can prepare for. And the important factor for me is the unique trauma a family must face when a parent or a spouse is cut down in the line of duty violently and suddenly. Members, this is a common sense solution for a real problem affecting families of our public safety officers. Joining me today is Ceres Police Chief Art DeWerck, who I might add went through this whole turmoil in the community of Ceres, the trauma that it affected his department. It affected the whole community. And so I think Chief DeWerck has a very important perspective on this. And so with that, I will allow you the Chief.
Sure. Senator Duchesne.
My biggest question here is why only law enforcement? I mean, the 19 thing at high school is what we do for child support in current law. There is a lot of discussion of the possibility of moving kindergarten date. You will have a lot more folks thrown into that category once we do that. So the 19 doesn't bother me, and it's consistent not only with Social Security, but with child support law requires you to pay until 19, or they get out of high school, whichever occurs first, which is one way you might look at this,
right.
19 while they're in high school. But what I don't understand is why, as much as they might be worthy, we would only do this for law enforcement officers.
You know what? I would answer that in the sense that you may very well be right. Maybe it should be more. But from my perspective, our public safety folks put themselves in the line of, in danger every day.
The oil workers in the Gulf about that.
Oh, no, you're absolutely right, Senator. But that is another issue that maybe we should look at this next year. But anyway, with that, let the Chief.
Good morning. Welcome.
Thank you. I appreciate the opportunity to speak.
If you could push your button.
Which one? There we go.
There we go. You're on.
Is that coming through now?
Yes. Thank you.
In 2005, Sergeant Stevenson was not only killed, he was executed. The assailant shot him in the back of the head twice while he was lying face down behind a concrete wall. The case that I'm talking about, I won't go into a lot of details, but it received worldwide attention because it was characterized at first as a disaffected Marine who was carrying some war-related trauma in his mind and decided to gun down a few police officers. So he basically, the suspects set up in front of a liquor store and had a AK-47, and he shot two of my officers, and of course, the one that we're talking about now was literally executed. So this was an extraordinary event, but it really highlights the situation where we have a young, basically a young teenage girl who lost her father. I happen to know that the two were very close. They would work out together in the gym down in the police department basement, and all of a sudden one evening, her father's gone. And it just seems to me that, as somebody who employs police officers, we have to give them an assurance that while all officers, myself included, are willing to give our lives to protect your lives, what we need to always have in the back of our minds is that our families are going to be covered. And that makes a difference between somebody who's prepared to carry out a heroic action versus somebody who's going to hang back because they don't know for sure if their families are going to be attended to. And I want to point out, too, that Michaela, and why this is so personal, especially in the medium-sized departments like the one I operate, the family becomes part of the police department. We can't ever let go of these people. And so we watch these there's two teenagers involved here, Michaela and the son Bryce, and they need kind of a surrogate family to help see them through. But when the mother is forced to go to work because the teenage daughter is still in school and now has to make up for the benefits that have been lost, not only has the father been eliminated from the scene, but now the mother is removed from the family environment at what I would consider to be a premature time. So this doesn't affect a lot of people. There's about 10 to 20 police officers killed per year in this state, and not all of them, of course, have these relatively unique circumstances. So I don't think we're talking about a major economic investment. I guess the other point is that I think that what is being addressed here is not anything particularly new. I think it was simply an anomaly in the original bill. So we're just trying to correct a small piece of law, and that's why I'm here to testify, is to maybe show you, how it's real. It's not a theoretical issue, and I'm available for questions if you have any.
Thank you, Chief. Any other witnesses in support? Witnesses in opposition?
Thank you, Mr. Chair and members. Jason Schmelzer with the California Coalition on Workers' Compensation. I will be playing the part of the villain in today's production. This is a hard bill to oppose. Our hearts are out there for any employee that dies, but especially those in the law enforcement community. We just have a very specific problem with the bill. If you look at when we first started doing presumptions as a category of law in workers' compensation in California, employers were told, no, it's just this one, it makes sense. The same, I think, applies in this situation. No, we're just going to expand past the legal age of adulthood for this one instance. But if you think about it, in the individual lives of the children who have lost parents in the workplace, there are several reasons why you may want to eventually expand the death benefit past age 18. We see here a slippery slope, and we think that it's inappropriate to go down this path. There is one consistent factor for all children of all employees who are deceased in the workplace. That is age. We don't think we should start making exceptions for certain professions and the children of those people in those certain professions. So with that, we'd urge your no vote.
Thank you. Any other witnesses in opposition? I'll bring it back to the committee for questions or comments. No questions or comments? Well, fully supportive. I do think this is not only an exception, I think, as you well said, it's an anomaly. Appreciate the author coming, and I think you can send the message back hopefully very soon that this bill will get signed into law, and to your family, that there's a larger family and community that supports the work you do and the families that you represent.
I move the bill, Mr. Chair.
All right. We'll call roll.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Senator Wyland? Duchenne? Hollingsworth? Leno? Leno, aye. Yee? Yee, aye.
You have 3 votes. We need one more, so we'll leave it on call. Thank you again, Chief. Thanks for coming up. That will bring us, I believe, to Assemblymember Knight is next. And then Assemblymember Ng, if he's still here. Good morning, Assemblymember Knight. Good morning. Item number 3, AB 2305.
Thank you very much for the time to present AB 2305. This is a simple bill that extends the sunset on a program proven to help with workers' compensation conformity in the roofing industry. This bill does not speak to safety issues, as the lone opponent continues to perpetuate. It only addresses the need for legitimate business practices. The roofing industry has one of the highest workers' compensation rates, and those high rates are typically due to underreporting in the industry, which in the end fails to protect workers and shortchanges the legitimate contractors. The program is shown to be an effective tool to improve workers' compensation compliance while protecting workers and creating a level playing field for roofing contractors. For most roofers, their C39 certificate is their only license, and urging that as collateral ensures that roofers are following the law. AB 2305 is sponsored by the industry, supported by contractors and labor, and funded by the industry. I have Mark Connerly with the roofing industry here to testify on behalf of the industry and answer any technical questions.
Thank you, Mr. Chairman and members. Prior to 2007, when AB 881 went into effect, there were more than 4,500 licensed roofing contractors who were able to maintain that license despite not having workers' compensation insurance. They were simply able to check a box on their license application which said exempt. And there's no verification process that they, in fact, have no employees. And by claiming exemption, they maintained that C39 roofing classification. Now, it's important to note that they had that license, which exposed homeowners who very often are oblivious to whether a contractor has workers' compensation insurance or not. They exposed their employees who were out on job sites without coverage, and they created an unlevel playing field for legitimate roofing contractors who had to include the cost of workers' comp insurance in their bids and compete against companies who did not have that same cost in their bids. It's also important to note that merely, under the old law, merely checking that box and claiming exemption and saying that you don't have employees, when actually you do, was a violation of contractor's license law, which is merely a misdemeanor. Under the current law, where you are forced to purchase a workers' comp policy in order to have your license and state how many employees you have and how much your estimated premiums are, if you misrepresent those facts, you are committing insurance fraud, which is a felony. So we've upped the ante on these illegal operators. As the Assemblyman noted, this is one of the rare bills that has support of management, it has support of labor, it has support of both union and open shop roofing contractors, it has support of trade associations within the roofing industry, as well as trade associations within the construction industry, but outside of the roofing industry. The only opposition is a group of attorneys who have no real ties to the construction industry. Within the industry, there's broad support for this bill. Now, there is data to support the effects, the positive effects of AB 881. I'd like to share that data with you. Workers' comp roofing contractor policy holders prior to 2007, there were a total of 3,411 licensed roofing contractors who maintained workers' comp insurance. Subsequent to the implementation of AB 881 in 2007, that number increased to 4,346, an increase of over 900 contractors who went out, bought workers' comp insurance, and were now in the workers' comp system. They're now subject to audits, and they are now subject to that felony that I referred to if they misreport their payroll. So that's an increase of 27.4% of workers' comp policyholders in the roofing industry. There were also more than 3,300 roofing contractors under the old law who were able to maintain their license without workers' comp insurance. When this law went into effect, they went away. They were no longer able to operate as a licensed roofing contractor. Now, I'd like to point out make one final argument, and it's something the opposition is going to argue. They've argued it every step of the way, and it's completely erroneous. And that is that if you take away a C39 roofing classification, you're somehow still entitled to call yourself a roofing contractor, and you're somehow still licensed. There seems to be this impression that there's like an umbrella license, and you just have a roofing classification underneath that. That is patently false. The C39 roofing classification is the license. That is the document which permits these roofing contractors to go to a homeowner and say, I'm licensed, I am qualified to install your roof. If you take that away, they have no license. They cannot operate legally as a roofing contractor in California. Thank you. I urge your aye vote.
Other witnesses in support?
Mr. Chairman and members, Scott Wetch on behalf of the Western States Council of Sheet Metal Workers. In support of the bill, we would like to associate ourselves with all the comments made by the author and the sponsor. Would like to take particular note to the committee that all the arguments made in favor of this bill in favor of increased enforcement could also be used to apply to greater prevailing wage enforcement. So we embrace those arguments and would urge your aye vote. Thank you.
Mr. Chair, Phil Vermeulen, representing the engineering contractors. As I said earlier, we're strongly in support of anything we can do on the workers' comp area and strongly support this bill. Urge your aye vote. Thank you.
Thank you.
Bruce Wick, California Professional Association of Specialty Contractors, strongly in support. Thank you.
Jeremy Smith on behalf of the State Building and Construction Trades Council, also in support.
Thank you, Jeremy. You're doing a fine job in your new position. Witnesses in opposition. Mr. Kim.
Mr. Chair and members, Doug Kim with the Applicants Attorneys Association. Our members represent injured workers, including injured roofing employees, and that is our interest in this bill. When the original bill was enacted in 2005, there were 2 points to the bill. I mean, we're very sympathetic to the issue of the high cost of workers' comp insurance for roofers, but it's high because it's a very dangerous industry, very dangerous. And I would point out that there are 2 different categories of roofing contractors that the insurance industry recognizes: those who are union contractors and those who are not. The premium rates for the non-union contractors is more than twice the premium rates for the union contractors. Now, this bill does not apply to union employees. I respect very much the trades who are in support of the bill, but I'm a little puzzled because this bill, I don't think, affects them. Union employees are going to make sure that their employer has workers' compensation insurance. To correct the record, there is a method when a roofing contractor says, I have no employees to check. You're all aware there is something called the Underground Economy Task Force, which is combined with EDD, the Contractor State Licensing Board, the DIR, Franchise Tax Board, and if somebody says, I have no employees, it's very simple for the Contractor State Licensing Board to check with EDD to see if, in fact, that contractor reports a payroll. And if he doesn't and he has employees, of course, that's a whole other matter. So what this bill does is, what the original bill did is 2 things. It said that if a roofing contractor did not have proof of coverage, then rather than losing his license, he would simply lose the roofing classification on his license. And this applies, if you read the language of the bill, to contractors who have more than one category of employees. So it could be roofer, electrician, carpenter, sheetrocker, whatever. And in the case of the latter, where they have more than one license, if they don't have the workers' compensation coverage for the roofer, they just lose the roofer category. They don't lose the license. This, by the way, conflicts directly with Senator Leno's bill, which would require, in that instance, an immediate stop order. It also conflicts with labor law, which requires that when the DIR discovers any employer or contractor does not have insurance, immediate stop order, suspension of the license. The other part of the bill, and we respect the intent, which was to help reduce the cost of workers' compensation coverage, was to, the other part of the bill required annual audits for 5 years of every roofing contractor by the insurance industry, and then a report to the Department of Insurance to presumably recommend, if they have been able to detect fraud or whatever, to go after that. None of those audits have taken place. None of that data is available. The numbers that the sponsors refer to are numbers that deal with pre-206 experience before the bill took effect. Now, I would also suggest to you that what you really want to know is not about those contractors who have the C39 classification. What you want to know is about those who lost the C39 classification. What happened to them? Did they go into the underground economy? Did they continue to compete for jobs and take a chance at being illegally uninsured? We don't know what happens to those people unless they are caught in an enforcement action, either by a Cal OSHA violation or complaint to the Fraud Assessment Commission or some such. The letters that I sent to each of you on this bill contained 2 recent newspaper articles of what's happening in the industry. I don't mean to suggest that it's because of the bill, but I want to make it clear that the bill has not stopped these practices. In one instance, a roofing employee was killed. And he was killed because he fell off of a roof. He did not have the appropriate safety equipment. There was no appropriate preventative measures in place, no supervisor to watch him to make sure he wasn't getting too close to the edge, things like that. That only came to light because of an OSHA investigation, and now that particular contractor is being criminally prosecuted. The article points out that he had misrepresented the classification of his employee and said, oh, he wasn't a roofer, he's something else. Okay. This bill perpetuates the encouragement of misclassification of roofing employees because it simply takes away the roofing classification from the license without taking away the license. Roofers in this instance would be the only employers and contractors in the state not required to have workers' comp insurance, but simply to lose the roofer designation on their license. The other article was a contractor who took his injured worker from here in Sacramento to a hospital in Woodland for surgery and coerced him not to file the claim. Ultimately, another former co-worker learned about this. They must have known each other, and he filed a complaint with the law enforcement authorities. There was an investigation. In this case also, the contractor had misclassified his employees as something other than a roofer and misreported the payroll. So not to suggest that this is something that is being encouraged by the bill, but it is happening. And the bill has the unintended consequence of then taking all of those injuries that are roofing injuries by these scofflaw, unscrupulous contractors, and their roofing injuries are not being reported as roofing injuries if they're being reported at all. And by not being reported as roofing injuries, then the overall cost of roofing injuries, which is the financial responsibility of the roofing industry, is being shifted to somebody else, either to other employers, or if these people do go into the underground economy, then it's going to be shifted to the taxpayers, because if there is medical treatment, it's going to be the emergency rooms, Medi-Cal. If there's going to be any financial subsistence, it's going to be general assistance or something like that. So we have a great deal of sympathy for the intent of the bill, a great deal of respect for the trades, the sponsors, proponents of the bill, but we think there's a very serious unintended consequence, and that is this encourages fraud. It encourages misclassification of employees, and it encourages people from not taking the appropriate preventive and safety measures. It seems to me much more if the sponsors should also make the attempt to reduce their costs by doing whatever it is the union contractors are doing in the way of safety and prevention measures and try to bring their costs down that way. So for those reasons, we respectfully and regretfully continue to oppose the bill.
Thank you, Mr. Kim. I don't want to get into a whole debate, but we've had some discussions. I have some concerns with the bill. I had some discussions, I think, as the author knows, through our staff about, at least for me, moving in the right direction. So although I share all of Mr. Kim's concerns, I think we have some amendments that will at least satisfy me to this point so that we're moving in the right direction in an industry that's been very hard to regulate, and I acknowledge that, but we're not within compliance of what the Emerson bill said in terms of reporting. So our amendments would go to that. It would require that you would be up to, the audits would be up to date as soon as possible, no later than January 1st of 2012, and that those reports, your bill would be amended so that it would come to the Secretary of the Senate so we would get to see that. And then secondarily, that the sunset would be moved back till January 13th. So I be direct with you and see if you're willing to take those amendments and the language we've drawn up. This is absent what other members, how their feelings may be. This is just for me to try to address some of the concerns that Mr. Kim has brought to me and my own personal concerns that I don't often quote President Reagan, but trust it, but verify. So this is an opportunity for the Senate to see that the things that you have said are happening, are actually happening, and we're bringing this industry into compliance.
Absolutely, and I do have a sponsor of the bill, so I will take just a brief second to chat with him. As far as the auditing, we are perfectly fine with the auditing, as long as we don't push this bill into a problem when we go toward appropriations and things of the bill. So we're a little bit sketchy on that right now. We do want the auditing. We don't want the problems as we move forward.
Okay, it's fairly clear. Be frank with you, the bill won't get out today if I don't have a commitment.
And that I know too.
Right, and I am trying to work with you, Assembly Member. I'm not trying to play a getcha. I just think there are legitimate concerns. I have talked to your sponsors, the trade specifically. They support the amendments, as at least has been conveyed to me. They think it strengthens the bill. So. Just want to be clear, and while you discuss that, I'll ask if there are any other questions or comments from committee members. Senator Yee.
Thank you very much, Mr. Chair. This issue was presented at BNP, and I sat on BNP. And I will tell you, after that hearing, it was almost like, he said, she said, and I supported it moving forward just to continue the discussion. This is the last policy stop. And, this is where I think we really need to ferret out exactly what this bill is about and what the arguments are. And if I can maybe have you, Assembly Member, respond to Mr. Kim's issues and with the indulgence of the chair, maybe have the building trades come back up and comment on that because it's and maybe one other point that I could just simply raise so that when you answer or comment about what Mr. Kim said, I think that in the analysis there is some validity to the concern that I think Mr. Kim raised, and it is on page 2 of the analysis. It's the second bullet about what this bill does. It does say that, in fact, the bill, if you read I think the beginning of the third line, the registrar shall remove the C-39 license classification rather than suspend the license, which is, I think, the point that Mr. Kim was raising, that you remove the classification, but you still have that license, and you can still, if I just read this correctly, then you can still continue to practice and whatnot. So maybe you can...
Before we get the response, I just wanted to follow up because my concern is identical to Senator Yee's. And if you look at page 3 of the bill, lines 21 through 27, that's the language in the bill to which the analysis refers in the concern of Senator Yee. why would we, in lieu of the automatic license suspension otherwise required under this article, remove the C39 classification from the license? Why not just automatically suspend the license?
You want to take that, or do you want me to? I'll take it. The C39 classification is a roofing contractor. That is the what we're addressing here with this bill. That is exactly how you become a roofer. That is how you do your roofing contracting. By taking that away, you are in essence taking away their ability to do the roofing contracting. You're not taking away their ability to do contracting work, in essence, but you are taking away their license to do that roofing contracting.
So again, we've got a bad actor here.
Correct.
They do other kind of contracting in addition to the roofing. Why would we not suspend the license altogether? We found a bad actor here. Who knows? And as we had a conversation on an earlier bill, just as we know when some employers are not paying certain taxes, it's likely they may not be paying other taxes. You've got someone, why not just suspend the license?
And I'll jump in there. It's an unfortunate use of words in the bill. If you have if you're a roofing contractor, you would typically apply simply for a C39 roofing classification. That's what almost all specialty contractors do. That they get their one specialty license. In this case, a C39 roofing license. And if you don't purchase your workers' compensation insurance, that license, that classification, which is where we're kind of arguing over semantics, that classification is taken away. You have nothing left. There is no license left. There is no legal means by which to practice your trade. And the trades will I'm sure, confirm this. It's an unfortunate use of words here. It's an unfortunate use of semantics that I think leads people who are not really familiar with contractors' license law to believe that there's some license that they'd still have, but they just wouldn't be able to do roofing. That's not the case. The C39 classification is the license. Okay. In some cases, they may also have a B or an A license, a general contractor's license, and they would not lose that. But that does not allow them to practice roofing solely. They could not go out and sell just a roofing job. They would have to do roofing in conjunction with other trades. Okay, and so that's where kind of the misunderstanding comes in.
But I think Mr. Kim's point, and again, I'm not as well versed in all of this as you, so you can instruct me here. But I think Mr. Kim's point that if we allow this bad actor roofing contractor to just have the roofing license taken away, they may still be contracting in other fields, and maybe will, as underground, continue to roof and push off those injured roofing workers into some other classification that they're still able to contract.
I think this is the scenario that this section pertains to, because I think there's been with all due respect to my good friend Mr. Kim, a little misimpression here. You can have multiple licenses. There are contractors who will be licensed in many different specialties, jack of all trades. They can only perform roofing work
with a C39.
With a C39, specific roofing work. They're not, the roofing category is the only category where we require a contractor with ostensibly no employees from having workers' comp. So I'm a single contractor, no employees. I have 5 licenses. One of them is a roofing license. Under the other 4, because I have no employees, I'm not required to have workers' comp. Only in this category. So so now I am found to violate, I don't have workers' comp. The concept here is that I lose my ability to have my C39 and to do roofing work. But that doesn't preclude me from continuing to work legally under my other 3-4 classifications in other areas. It might be, sheet metal or whatever it might be. The impression I think that was given by Mr. Kim's testimony is that this language allows me to have my license suspended and then go and somehow legally, with the color of law, go and perform roofing work. That's absolutely not the case. Sure, I can go do underground work, but if you take that logic to its fruition, then we shouldn't be increasing penalties for people who get convicted of DUI, because this is going to encourage them to drive without a license. Well, that's always the issue.
A greater disincentive if the license suspension, not just the C-39 classification, were to be suspended? That'd be a greater disincentive, because then you couldn't go off and do your other contracting.
I think that the change in, if you want it, my personal view is the verbiage here, you would put remove, revoke, suspend. It still has the same impact, that they can't continue to go legally use a C-39 or go and bid on roofing work. I mean, you have to provide your contractor's license whenever you bid.
No, but my point would be, if, as you pointed out, this particular scenario you've drawn, there would be no ability to perform the other licenses.
Personally, I don't think that would be fair, because the law doesn't require a sole proprietor from carrying workers' comp in those other fields if they have no employees. And so oftentimes it just may be an economic circumstance that prevents somebody from being able to maintain their workers' comp.
Let's draw a slightly different scenario. So rather than having no employees for these other areas of contracting, as you've suggested, this contractor just has employees for roofing. Let's say they have 1, 2, or 3 in the other areas as well. Yeah. Then they're required to have workers' comp.
They are.
Right. And so, first of all, we might want to look into whether
I agree.
The contractor has.
It's just another bill.
Well, what if we were to suspend the license across the board for this individual? That's a greater disincentive not to carry the roofing license, roofing workers' comp.
And that it just goes. I mean, I won't speak to that, because I don't particularly, my client doesn't have a problem with it. But as far as the bill goes, what it's really trying to get at is that legitimately sole proprietor that has no employees and is not following the law and having workers' comp for himself. I don't know if it would be fair then to revoke the other licenses for which that scenario is allowed. But
I guess beyond fairness, would it be effective? I mean, it just seems intuitively, if you value all of those licenses, you would want to be able to not avoid your workers' compensation. If you found that you have been illegal on your roofer's contract, why would the state of California want to continue to license you in the other areas?
I wouldn't have a problem with that. I just think this is a very important policy that we need a signature on. And this program has been very effective, and we need to continue it. And for the marginal impact that change would have, if the bill doesn't get signed, and I don't know how the contract...
It's got to get to his desk first.
Yeah. I don't think it's germane to what the bill is attempting to do.
Okay, appreciate it. Any other thoughts, Mr. Leno? You're still thinking, Mr. Yee.
Well, I think that the discussion's been rather valuable. I think that what we're reading in the bill is exactly what Mr. Kim is hypothesizing may happen, and that is that you can wipe away the roofing classification. You can't do roofing, supposedly. And then what Mr. Kim is saying is that, well, you can wipe that away, but then you'll still have a license. You can then go to, a home or whatever and say, I have a license. I have a contractor's license. I can do that roofing. And I've already lied about my workers' comp, so I can lie about my the fact that I don't have a classification to do roofing, but I've got a contractor's license, and that's where you go underground, and then you create the kinds of problems that Mr. Kim is talking about.
Well, if we never believe there's going to be an underground construction trades or underground license problems out there, then I'd love to see that bill. Because there's always going to be problems with people getting work that they have maybe duped a homeowner into allowing them to do. I don't understand his logic when he's going down this road. We're not talking about a bill that is going to change what we have done over the last 4 years. We're continuing on what has been working over the last 4 years. And the fact that there are going to be people that are going to get injured on the job and they are not going to be under a certain license is still going to happen. The fact that there are going to be people that are going to be injured that are not taking the proper safety conditions, that's still going to happen. The fact with this is that the bill was written so that we could get more of the contractors to understand that workers' compensation, we want you to have workers' compensation because this is the highest rates in the construction trade. It has been working. It has proven. And the fact that the data that we are seeing now, because it takes 1.5 years of the audit, the data from 2006 to 2007, when the bill was being implemented, raised workers' compensation. That means the contractors that have workers' compensation by 27%. Just knowing that this bill was going to become into law has the effect of this bill. That has the effect. We are getting more contractors to have workers' compensation. That is a fairer playing field for all contractors when they apply for certain jobs.
Well, and I think because of that good thing, I don't think that you're hearing from the committee that we want to kill the bill. But what you're also hearing is that there is that potential unintended consequence that while this bill is not going to wipe away that underground economy, but the bill, by voting for it, you will be also aiding and abetting, that particular problem. And that, I think, is what is coming out of the discussion, at least for me.
Senator Leno tells me he's got another idea, so okay.
A feverish mind at work here. So, as the bill's worded here, you're caught without your certificate of workers' compensation. You have your C-39 classification suspended.
Correct.
But if you have you still have a state contracting license. What if, so then I'm the bad player, I go get my workers' comp. 6 months later, I'm caught a second time. I'd like to see in that second offense, your state contractor's license is taken away altogether. You've been caught twice now. You can't do any contracting legally in California. How does that fall on your ears?
At first blush, I'm inclined to support that, to go along with that. Now, I do want to point out that we're talking about, when we're talking about these contractors who also hold another license, like a B license or an A license, we're talking about roughly 1/6 of all of the contractors who have C-39. So roughly 85% of them just have the C-39.
So 5/6, when they lose their C-39, they aren't contracting in California.
Exactly. Okay. Exactly. So we're really talking about the exception here rather than the rule. So I want to speak to that. Second, and Senator Yee really asked us to kind of respond to some of Mr. Kim's comments. Unfortunately, again, many of the opponent's arguments are just completely false. At first he said it doesn't apply to unions, and then he said, well, I don't think it applies to unions. I defy you to find any place in this bill where it says that it doesn't apply to unions. It absolutely applies to union and open shop. That's purely a red herring on his part. He said that workers' comp rates are higher for unions. Insurance companies don't set a different rate for a union workers' comp rate for a union employee versus a non-union. Again, that's patently false. So he's continuing to perpetuate misinformation here, and he's thrown up red flags, and unfortunately, the committee, I think, is buying into some of this.
Senator Yee asked indulgence of the chair. At least for myself, it's not buying into. I think there are legitimate concerns being expressed by all of us. There are 4 members due to be here today. You'll need all 4 votes to get it out of committee, so to be perfectly frank. Okay. I think there are legitimate concerns. I think we all want the work to continue to go on, but we want to make sure that it is going on. And to the degree that we're making progress, that's fine, but the benchmark is against an industry that wasn't in very good shape vis-a-vis the rest of the industry in the first place. And then lastly, there's been a failure to report under the existing law. There's a 3-year lag on the audits required in the Emerson bill. So that raises a red flag to me, separate and apart from Mr. Kim, because you're at least in appearance ignoring the language in the bill right now by Mr. Emerson. So we just want to correct those things. Personally, sitting here, I think it's eminently doable. May not be to the satisfaction of Mr. Kim. So my suggestion would be that maybe we could work on a language. We don't have a quorum here right now, and see if we can come up with something. There are some very bright minds in the back of the room who are working on it as we speak. We've got about 20 other items, and then we can bring it back.
And absolutely, I don't want to,
because we don't want you to do this in a hurry and get it wrong either.
Push this
in
too
an
far.
Extreme hurry.
But we have gone through several committees. We are willing to work. I think everyone can understand that this has good merits, that we want to move this forward. The amendments that you've brought forward, I do have no problem with. And I do want to continue on this process. So,
and they're offered in with respect. I know you've put a lot of work into it. I'm not trying to, do anything but try to make it better for. Well, I think we all are. And that's what I get from both Senator Yee and Senator Leno. So if that's amenable,
I think you're fine. Well, Mr. Kim, did you want to respond to comments made relative to the earlier comments?
I just think
and can I just caution both of you? We've got a long agenda. The reason I jumped in is both of my colleagues want to hear from both of you. So let's give you a moment if you can.
Yeah, I just
can
want
have
to
a
say
reasoned, not he said, she said. That'd be
I
great.
just want to say the proposed amendments, I think, make the bill more palatable. Our concern has always been we do not believe there's any credible data that would vindicate this approach. If that data surfaces, and if it's valid, I mean, if it's credible, as I've said all along, then we would have no problem with continuing the program. We just saying in the absence of credible evidence.
So are you challenging, I'm sorry to drag this any further, Mr. Chairman, but are you challenging the 27% increase in roofers who are now carrying
No, but I don't think we can automatically assume that any increase in the number of covered
was due to
it was due to the Emerson bill. Okay. It could be any number of things. The other thing I'd just like to point out is because this bill, because simply removing the license does conflict with your SB 1254, that somewhere along the line you're going to have to amend both bills to avoid a chaptering out problem should both be sent to the governor. So.
I want to look into that. Well, that's why I was suggesting on a second offense that the license would go away altogether.
Thank you.
Thank
Do you
you,
have
Mr.
anything
Chair.
else, Assembly Member, or your witness? I cut you off just because I didn't want to get in a whole
I
WWF discussion.
I appreciate the discussion by all members, and I think that everyone can see that moving this forward is in the best interest of the state of California.
Sounds like it's fairly simple in order to get it out of the committee, and I do want to thank everybody, and I didn't mean to be flip with Mr. Wetch. He's a good friend, and I appreciate it. But if you were to take our amendments, and it sounds like a very specific suggestion from Senator Leno, it seems like we could come back and move on. And I don't expect Mr. Kim will be supportive of the bill, but it would help you get the votes to get it out.
Appreciate that very much.
Thank you.
Thank you.
Mr. Chair, I just mentioned, I think that there was a staff from B&P who analyzed this bill, and that he's made his service available in terms of crafting whatever the amendments. Okay.
Okay. And to the degree that we can sacrifice a committee consultant, we'll do that, knowing that they're manning multiple bills. Thank you. Sorry for the long hearing, but we'll get it done. Okay. Mr. Ng. An easy, thoughtful bill.
If that's possible. Anyway, thank you, Mr. Chair and members. This bill, AB 2523, is simple and hopefully thoughtful. It would permit state-approved apprenticeship programs to offer certification training under their general control without the requirement that this training be under the jurisdiction of a community college or school district. Currently, electrical training programs have been primarily but not exclusively provided by community colleges. Unfortunately, in many areas, trainee programs are not being offered at the local community colleges or are not being offered every semester. This has created serious difficulties for workers who cannot work in their field without being enrolled in such a course. This measure would help remove barriers and provide opportunities for trainees to get certified, get into the job market. I'd like to thank all the stakeholders for their efforts to make this bill work. The measure is supported by the California Association of Electrical Workers and is sponsored by the Western Electrical Contractors Association. So far, the bill has received bipartisan support. Respectfully request an aye vote. I have here witnesses in support.
Witnesses in support.
Mr. Chairman, Richard Marcus and Western Electrical Contractors. Mr. Ng did a great job of characterizing the bill. We're seeking, as a state-approved apprenticeship program, to eliminate the duplicate supervision that we currently are required to comply with our local education administration. There are standards in the bill that we inserted at the request of the community colleges to ensure that these programs meet 6 standards for protecting the students' rights. It's our second effort to work collaboratively with the other contractor groups and labor in California to modernize the law that's been on the books for 11 years. Thank you.
Mr. Chairman and members, Scott Wetch on behalf of the State Association of Electrical Workers. We sponsored the original bill creating the certification program and have sponsored every piece of legislation that has been enacted on the subject, with the exception of this bill. Hopefully it will be passed. Basically, the problem is, in order to be able to work as an electrician or work on electrical work in California, you have to either have already passed the certification exam, you have to either be in a state-approved apprenticeship program, or you have to be in a trainee program. And the problem that we face is oftentimes we have members who come from other states, who are traveling from other states, have moved to California. They haven't had an opportunity to take the test yet. They graduated from an approved apprenticeship program many years prior, so they can't go back and re-enter an apprenticeship program. So the only avenue for them to work is to be in a trainee program. And unfortunately, in many parts of the state, the community colleges don't provide the classes, or they don't provide them every semester. And so then people find themselves just unable to practice their craft. So this is an elegant solution, and we believe, and what it does is it allows approved apprenticeship programs, union and non-union, to provide trainee courses just to their own workers, employees, and members. We worked collaboratively with the community colleges. We think that it deserves an aye vote and would encourage that. Thank you.
Thank you.
Mark McDonald, McCallum Group, on behalf of a number of community college districts, Los Angeles, Los Rios, Yosemite, San Diego, and the LA College Faculty Guild. And we had been opposed to the previous version of the bill. We'd like to thank the author, the sponsor, the proponents of the measure for working closely with us, and we removed our opposition. Thank you.
Any other witnesses in support? Any witnesses in opposition? Any closing comments from the brilliant Mr. Ng?
Not brilliant, but respectfully request an aye vote.
Okay, is there a motion?
Yes, there is. I move the bill.
Motion by Mr. Leno. We'll call a roll.
Senator DeSaulnier.
Aye.
DeSaulnier, aye. Wyland, DeCheney, Hollingsworth, Leno.
Aye.
Leno, aye. Yee, aye.
You have 3 votes. You need 1 more. We'll leave it on call. Thank you.
Okay, thank you very much, Mr. Chair and members.
Welcome, Assembly Member. You have a couple of items, so whatever your pleasure. Where would you like to start?
Start with AB 933, utilization review. Morning, Mr. Chair and members. AB 933 clarifies current law and protects California workers by providing that physicians performing workers' compensation services, particularly utilization review, must possess a valid California license. Current law requires a physician making diagnosis decisions to be licensed in California. This same law also defines utilization review as the ability to review, approve, modify, delay, or deny treatment recommendations by physicians. This process inherently involves making a diagnosis of the underlying condition that caused the request. Therefore, utilization review is a practice of medicine and should require a California license. Physicians not licensed in this state frequently do not understand the unique California-specific regulations the Administrative Director of the Division of Workers' Compensation has required in governing utilization review. Unlike any other state, California licensed medical doctors must obtain 12 hours of special education in pain management, the leading cause of disability in the area of workers' compensation medicine, where proper application of California's hybrid guidelines is essential. Most California insurers and self-insured employers already use California licensed physicians. There's no evidence that they are experiencing delays or increased costs. In addition, AB 933 is amended to increase transparency by requiring that insurance carriers disclose the cost containment fees to the employer employers to clearly establish which, if any, of the medical fees end up in insurance carriers' own pockets. This bill will also ensure that workers have access to all medically necessary health care and that such care is close in proximity to the residence or work. Finally, AB 933 will be good for the economy. It will ensure that virtually all workers' comp review will be done by physicians who live, work, spend money, and pay taxes in California. And I have several witnesses here.
Please go ahead, witnesses in support.
Good morning, Mr. Chair. Carl Brackensick on behalf of the California Society of Industrial Medicine and Surgery. Assemblyman Fong has done an outstanding job of outlining this bill. Simply stated, AB 933 will improve the delivery of needed health care to California's injured workers. The overwhelming majority of physicians performing UR in California have a California license, but some do not. The current administration has taken the position that these doctors do not need a California license, even though the Medical Board of California says they do. The state fund and most of the larger workers' compensation carriers in California exclusively use California licensed physicians right now, and so they're already in compliance with this legislation. When we surveyed our members a couple of years ago, approximately 80% of the UR disputes involved physicians who are licensed elsewhere, and only 20% of the disputes involved California licensed physicians. UR disputes cost employers money in California, and California licensed physicians have a much lower incidence of UR disputes. AB 933 will make UR work the way it was supposed to work in SB 228. If, as the opponents say, AB 933 will increase costs, we must ask the question, why are most insurance companies already using California licensed doctors? Finally, none of the opponents that you will be hearing from have refuted the medical board's position that performing UR is the practice of medicine. Merely because the medical board does not presently have the resources to prosecute these violations of law is no excuse for us to permit them to continue. I now will ask Steve Katolika to comment on the recent amendments to this bill.
Could I just confirm one statement, Mr. Chair? Did you say that 20% of the utilization review disputes are with California licensed physicians and 80% are non-California licensed?
No, the disputes, the conflicts between physicians and the UR doctors, when our members have a dispute with the UR doctor, 80% of the time the doctor is an out-of-state doctor, whereas California licensed doctors who are much more familiar with the workers' compensation system are basically able to get to the answer sooner, and there is not a dispute.
And not to draw this out too far, but would you suggest that the reason for that is that these doctors have greater legal familiarity with our state law as opposed to any kind of benefit of medical training?
I would say yes. That's correct. They have a greater familiarity, they have a better working knowledge of California's unique medical treatment utilization schedule, which is unique to the state of California.
Workers' comp
yes,
statute.
Sir.
Okay.
Yes, sir.
That's all I needed. Thank you.
Go ahead, Steve.
Thank you, Mr. Chair. My name is Steve Katolika. I represent one of the co-sponsors, the California Society of Physical Medicine and Rehabilitation. Very quickly, the amendments to Labor Code 4616 are meant to not only reinforce the main tenet of AB 933, but also to amplify the findings of the Division of Workers' Compensation study on access that was commissioned in 2008 and recently released based on a public records request by the California Society of Industrial Medicine and Surgery and Assemblyman Solario, chair of the insurance committee there. In that study, among other findings, they found that of the workers polled, 80 to 85% were covered under MPNs. At the same time, they found that roughly 3.8 million avoidable lost days were caused by access problems caused by either UR or not being able to get to a physician. That, they estimated, cost $349 million in the first year post-date of injury. So we believe that our amendments in Labor Code 4616 to create better accountability by recertifying every 3 years, by making sure that the administrative director develop regulations that require the list of physicians to be updated no less than twice a year, all play to the point. In addition, our amendment to Labor Code 4616F recognizes that the medical treatment utilization schedule is inclusive of the ACOM guidelines as well as others, and so there's no longer any need to name them specifically in that statute. The MTUS, as it's known, the medical treatment utilization schedule, is not only encompasses those but many more. And finally, our amendment to Labor Code 3762, requiring that insurance carriers and claims administrators create transparency with respect to their costs for cost containment, telling their insureds or their prospective insureds how much they spend on cost containment fees, is in alignment with the Department of Insurance's recent change in the work comp benchmark that now will require carriers to separate that number out, that cost of cost containment, those fees, away from medical costs, and name them now as loss allocation expenses. We believe that that kind of transparency between a carrier or a claims administrator and their prospective client or their clients is important.
Thank
Ask your appeal.
Other witnesses in support.
Good morning, Mr. Chair and members. Doug Chiappetta on behalf of the Union of American Physicians and Dentists. We are an additional co-sponsor to this bill. I would add that we are affiliated with AFSCME, and AFSCME is the prime sponsor of this legislation. Real briefly, this bill was run a couple of years ago as AB 2969 under Assemblywoman Lieber. We've made some changes to the bill. 3 quick points that I wanted to reiterate. One, Assemblyman Fong noted about the economy and the impact on the economy if you had all California licensed physicians. Secondly, this bill was originally drafted to address a loophole in utilization review law, which indicated that such procedures were to be done by a licensed physician in California. I don't think it was the intent of the original law for it to be a non-licensed physician in California. And finally, the point that Senator Leno made, yes, there is a greater familiarity on the part of physicians licensed in California with regard to utilization review laws and procedures. So we ask for your aye vote, and thank you.
Thank you, Doug. Other witnesses in support?
Thank you, Mr. Chair and members of the committee. Carolyn Jenna with the California Medical Association in support of the bill. And thank you to the author for his leadership on this issue.
Well said.
Thank you, Mr. Chair and members. Angie Way, California Labor Federation, in support.
Doug Kim with the applicants' attorneys, and we're in support.
That's a good sound. Anyone else in support? Anyone in opposition? See how quickly you can move, Theo. Hi.
Mr. Chairman, members, Theo Payos with the Association of California Insurance Companies. We'll let others comment on the first section of the bill relative to licensing. That matter's been before this committee. We've testified in opposition. I think you'll hear those arguments from witnesses coming after me. The part that has really sort of got our attention here is the newly amended section relative to MPNs. We need to stop thinking about an MPN as a group of insurance poker players that have friends with doctors in this nice little cabal. Our members are large members who insure employees up and down the state of California, lease very large networks of physicians that comply with the medical provider network regulations that are set forth by the department. These are huge, and they were meant to be, so that you had a lot of access. You could essentially, your doctor in group health was probably also in this network, although that's not always the case. But these are large networks, and people change in and out of these networks all the time for reasons that have nothing to do with workers' compensation. They quit a particular medical group, they stop a particular relationship with a payer, they move around in these things even as they retain their own actual office. These are contractual relationships that are very complex and are in great number out there in the California delivery marketplace. To essentially require under the penalty of perjury that we sign a document that there hasn't been any changes is really quite ludicrous, for lack of a better word. You could literally have changes in a network by the time you grab the pen to the time you actually make the signature on the certification. There is a very healthy and aggressive set of MPN regulations that have been drafted with the input of all the parties involved. We haven't always necessarily been happy with them, I have to admit, but they have been a compromise. And that would be the appropriate place to make sure that the certification of the networks is done in an appropriate manner. But at the end of the day, the interest shouldn't be that you're able to hold up these networks just because, for instance, a particular doctor went in or out of that network. The interest should be in making sure that an employee knows when his or her doctor has left the medical group and is no longer part of that network. That's not what this bill does. This bill really, in our opinion, is just creating a loophole or a leverage that can be used against insurance and employer parties as a way of really legal harassment. Your MPN network isn't valid because a certification was done and there was a change that was not noted in that certification, and then we end up with just more legal frictions, which is just more cost to the system. So again, this is the provision that we really find difficult, and would ask that you oppose the bill until that's taken out. Thank you.
Jason.
Thank you, Mr. Chair and members. Jason Schmelzer with the California Coalition on Workers' Compensation. I will hit the first portion of the bill. Again, there are substantial regulations on utilization review in current law. They apply to doctors in the state and out of the state. The DWC does have the ability to impose fines and penalties on people who violate the regulations, even if they are out of state or licensed out of state. So the fact that the California law does not touch these folks is just not true. It has been said that current law does require these people to be licensed in California because it's the practice of medicine. I just looked at a previous bill analysis by the Medical Board of the State of California for a previous bill, AB 1073, and in their analysis they said that it did not require it under current law, and I'll tell you why. Labor Code Section 4610E specifically requires any physician who makes a decision to modify, delay, or deny treatment to have 3 qualifications. 1, that they're acting within the scope of their practice, they're competent to evaluate the specific clinical issues involved in medical treatment, and then there was one other that I actually didn't write down. I apologize. In the section right before that, 4610D, it talks about the medical director for the UR company. And in that section, it does require the medical director to be licensed in the state of California. I honestly doubt that the people who drafted the law forgot from 4610D to 4610E to include that provision. So the way the law is crafted, it very much seems as though it was not intended to have that specific requirement. So it is not in current law that they are required to be licensed in California. All of the same regulations apply. There is no difference. The guidelines that are in the medical treatment utilization schedule are nationally based, peer-reviewed, evidence-based guidelines. Doctors in California are no more qualified to look at those guidelines and make a decision about treatment than doctors outside of California. Workers' compensation is constantly criticized for the cost of delivering $1 of care. What we would ask is if you're going to make that criticism and it's fair, please don't make it more expensive. So with those points, we'd like to urge your no vote. Thank you.
Good morning, Mr. Chairman. Senators Julianne Broyles here on behalf of the California Association of Joint Powers Authorities. Very briefly, we do think that AB 933, as it's currently written, one, will create a logjam of utilization review requests going through the system by requiring a California-only physician to do the UR. Secondly, we don't think it's appropriate to add a new felony into the labor code for any reason, and for the reasons are opposing the bill.
Good morning, Thomas Vu with the California Chamber of Commerce. We are in opposition because we believe the bill would increase costs to employers as well as create a logjam of cases. Thank you.
And Irene Ortega, California State Association of Counties, in opposition for the reasons stated.
Natasha Carl on behalf of the League of California Cities, also opposed.
Iris Herrera with the California Special Districts Association, also in opposition. Amber Wiley with the Alpha Fund, also in opposition.
Michael Corbett with the CSAC Excess Insurance Authority, in opposition.
Okay. Questions or comments from committee members? Mr. Fong, do you want to, or Steve, want to address some of the concerns, particularly from Theo and others?
Yes, I can. Again, Steve Catolica with California Society of Physical Medicine and Rehabilitation. The provision to sign under penalty of perjury has to do with their recertification of their entire MPN. That a network might change from day to day. I used to manage a network. I ran the state's largest HCO, which are the precursors of MPNs. I know about that kind of issue. And that's one of the reasons why we also included a provision that MPNs update their lists every 6 months. And and recertify every 3 years, similar to HCOs. The statement under penalty of perjury is just gives them the ability to say that nothing of substance has changed in their MPN. If they're updating their network every 6 months, as would be required by the statute, and they're recertifying every 3 years, that would those would all satisfy the issue. I would also add that the same access study commissioned by the Division of Workers' Compensation and researchers from the University of Washington recommend that MPNs become the locus of quality improvement in the workers' compensation system. And whether you happen to agree with that premise or not, it appears that the division is being told that by outside researchers, not people that have made a conclusion and found research to support it, but the other way around, the MPNs ought to take on more responsibility, not less. So it seems to me that our amendments are quite in line with that same thinking. The provision that physicians be licensed in the state of California has nothing to do with claims audits or claims audit penalties. It has to do with accountability for their own medical decision making. A physician in Florida who's not licensed in California who makes a decision to deny a treating physician's request for treatment, and that injured worker dies because of that determination, can't be held liable the same way that treating physician that requested the treatment can. We believe that, and the medical board apparently agrees with us because they believe it's the practice of medicine. They believe that that individual who makes that determination to deny care should be equally accountable. So it has nothing to do with claims audits. The medical director licensee, yeah, they ought to be licensed too. There's no question that's true. But that has nothing to do with who the vendor might be and the individual independent contractor utilization physician who's given the file to take a look at. And finally, with respect to a logjam and requests, there are going to be no more requests than there were before. And they seem to be being handled very well. Not only that, but the division itself has come out and said that they recommend that utilization review be streamlined, that not so many requests go to utilization review and incur those costs that others have talked about, that there be made a better way. And so we believe that AB 933 is completely in compliance with all of those things.
Mr. Fong, do you have anything to add?
No, I just respectfully request an aye vote.
Okay, we will. Is there a motion?
I have a question.
Senator Yee.
To your sponsor, Assemblymember Fong, your sponsor basically said that the liability is going to fall on, that part of the change that is in this particular bill that you are proposing is, in fact, to have individuals sign under penalty of perjury if there are any changes. Your sponsor indicated that, well, the physicians are already liable for whatever conclusions that they make, denial of services, or whatever it may be. If that is the case, then why add in this bill that additional sort of hurdle or that additional requirement of signing under penalty of perjury?
If I might, Senator Yee, the two are not related. The accountability from a UR physician, it has to do with the medical determinations that are made on a day-in and day-out basis for treatment for individual workers. The penalty of perjury declaration that we're talking about has to do with the recertification of the entire MPN once every 3 years, and it gives the MPN owner or applicant the opportunity to simply say to the division that we've made no changes in our program and alleviate the paperwork that might be involved in recertification.
Thank you. Senator Leno.
Under penalty of perjury, I believe in all cases in California, is a felony. Can you confirm that?
I cannot confirm that in all cases it's a felony.
I believe that's the case, because we've bumped into this before in public safety. I don't know why this wasn't brought into the Public Safety Committee, because then this is going to bump into our ROCA policy, because it could aggravate the overcrowding problem in our state prison.
Well, I'd hate to think that our MPN applicants are all going to end up in prison, but I understand what you're saying.
I mean, and the reason I bring this up is that Assemblyman Emerson had a bill last year. I don't even remember the issue area, but it created under penalty of perjury, and we had to change that language because otherwise it was going to bump into our ROCA policy.
Do you have a suggestion, sir?
Well, the reason is because of the amendments, I'm told by staff, but it is going to appropriation, so we probably should try to clarify it before.
Okay. Don't mean to cause the bill trouble, but I just noticed that.
He's the master of public safety.
It's got to be consistent.
Okay. Any other comments? Or do we have a motion?
So moved.
It's moved by Senator Leno. We'll call a roll.
This is not amended, is it?
It's not amended, no. And it's to move to appropriations. There's no amendment, but there is the discussion that needs to happen that Senator Leno brought up before that about its relationship to public safety.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, DeCheney, Hollingsworth, Leno?
Aye.
Leno, aye. Yee, Yee, aye.
Okay, that's 3-0. You need one more vote to get out, so that'll be on call. We'll take that to your second item, Mr. Fong. Item number 15, AB 2349.
Good afternoon, Mr. Chair and Senators. AB 2349 is California Youth at Work program. In the summer of 2009, nearly 50,000 low-income youth in California were employed through the California Youth at Work program, partly due to the temporary stimulus of federal funds. Youth participants gained work experience in paid positions and learned how to search for a job, workplace etiquette, and technical skills. However, without consistent federal funds and a significant decrease in Workforce Investment Act funding over the last 9 years, only a few youth programs remain. California's low-income youth have had the most significant decrease in employment rates. AB 2349 will ensure that the California Youth at Work program will be a permanent resource for low-income youth that will give them an opportunity to gain vital work experience within the guidelines of the Workforce Investment Act. Eligible participants in the program will include low-income and disadvantaged youth. In the program, youth are paid no less than the state's minimum wage, and high school graduates are paid the equivalent to that of adults performing the same jobs. According to the Center for Labor Market Studies, if youth work in high school, they tend to receive a number of labor market and educational advantages, such as higher employment rates and wages in their late teen years, as well as a lower probability of dropping out of high school. AB 2349 can offer disadvantaged youth the guidance they need to be competitive in the workforce while encouraging them to finish high school. I respectfully request an aye vote to have some witnesses here, too.
Go to the witnesses.
Thank you, Mr. Chairman and members. Jennifer Mitchell with the California Workforce Association. We're sponsoring this bill. As Mr. Fong, our bill author, who we are very grateful to, said, nearly 50,000 youth went to work last summer. We expect in the reauthorization of the Workforce Investment Act, which many people are saying behind the scenes isn't going to happen, but we do expect to see a summer youth component in that bill. We do know there's a secret Senate bill that we expect to see unveiled before the summer recess in Congress. There was a similar bill vetoed by the governor last year. Some folks believe that we already have this in code. In fact, there is a year-round youth employment program that is part of the Workforce Investment Act that has been codified. There's not a summer youth employment program that has been codified. We would like to see this in code. We would like to ensure that there are elements that are defined, such as the term of summer, the age of the youth that will participate, the wages, and we would like to see eligibility criteria expanded to include youth whose parents or guardians receive unemployment insurance or are in a Workforce Investment Act dislocated worker or adult serving program. And when we talk about other funds, we're talking about maybe other funds coming from the federal level. The Workforce Investment Act could be called something else. We don't expect general funds to fall out of the sky. With that, I'm going to actually turn this over to one of our summer youth participants. We have Michael Golden, who participated last summer. He's from Senator Duchesne's district. I am now referring to him as Michael Golden. This young man is incredible. He graduated from high school on Monday, so I want to congratulate him. And I'm very proud to say that he will be attending UCLA beginning next month. So with that, I'll let Michael tell you his story.
Good morning, Chairman and members. To some students, the Higher Youth Program was just another summer job. To some students, it was all about trying something different. To other students, it was all about making enough money to buy new clothes, delay cell phones, gadgets, and gizmos. But to me, the Higher Youth Program was a relief to my family's pain. This program has changed my life. It has drastically changed my circumstances. Without Higher Youth, I wouldn't have a job. There used to be a fine line that separated youth jobs from adult jobs. But over the last few years, that line has dwindled and perished. It feels as if finding a job is equivalent to finding a needle in a haystack. Everyone, from 50-year-olds to 15-year-olds, is fighting for that one little McDonald's job. Because what may seem like an insignificant McDonald's job can mean the difference between your family eating and your family starving. In this current economy, people have lost numerous things. Some have lost cars, savings, and many have lost homes. But I've never really had a home to lose. I hear a lot of people saying that they don't have anywhere to go. But that's absurd. Many can simply go over a friend's house or relatives, maybe a teen shelter or even a family shelter. But that's still somewhere to go. They might not be willing to go there, but they still have somewhere to be. But when I say, and with the quiver in my voice, that my mother, my sister, and I had nowhere to go, that is exactly where I mean. Think about this for a minute. Where'd you go when your grandmother closed the door on you, laughed, and said that being homeless is what you get? Where could you go when homeless organizations claim to place you in a motel for a month and without even notifying your family, run out of funds your first week there? When you come to them with your face drenched in tears and they basically tell you, good luck. Where would you sleep at night when your first cousin, whose living room is where you slept, moved out on you in your sleep and left you there? When shelters toss you out on the street when your time is up, or when shelters are too full to accept you, or the only way they could accept you was to split up the only thing you ever had, which is your family. Where would you go when friends turn a blind eye to your struggle? Where could you go? That was my question. Where could my family go? My mother was doing her best but couldn't possibly do it on her own, and the extra help she needed just wasn't there. What happens when a job doesn't pay enough and you need to buy food? Hunger happens. Food stamps help until they closed our account. This was me. This was my reality. My sister and I would eat at school, then save the scraps of food from school and bring it back to our house of a car so my mother could eat. This is how it went for a long time, until one day I stumbled across a piece of paper that read Higher Youth Program. To me, this paper read hope. It meant food. It meant sleeping in a motel at night. It meant a lot more than what it actually read. Now let's fast forward past the certification process and the work readiness training to when I received my first paycheck. If you were to look into my eyes that day, you would have sworn I was Bill Gates. $279 plus 54 cents seemed like billions to me. That week I purchased toiletries, bought gas for the car so my mother could get to work, did the laundry, and purchased other necessities, which allowed me the chance to step up and finally become the man who can now be depended on. The Higher Youth Program has allowed me to provide for my family, gave me more work experience, and has helped me change my family's residential status. Due to the generous pay rate at Higher Youth, I was able to help pay the rent deposit, moving my family out of our car and into an apartment, and fill it with food. Our days of struggling with hopelessness are officially over. The Higher Youth Program helped change my life, and life-changing events will never be forgotten. I want to thank the entire HAY program for giving me this life-changing opportunity, and especially my case manager, Tara Anderson, for being so flexible and understanding. I deeply express my gratitude to the HAY program because it has made a tremendous difference in my life. Thank you, guys.
Thank you, Michael. Great job. We needed that. Next witness.
Hi, Mr. Chairman. I'm Nancy Vandell, representing the California State PTA, and it's difficult to follow someone as eloquent as this young man over here, but it really puts things in perspective. I fully expect to see you up here someday.
I think he aspires to higher things.
Perhaps.
Not that we don't need you.
Oh no, I mean up with the legislators up there.
Oh, staff.
No, with all of you.
Go ahead,
Anyway,
Nancy, I'll be quiet.
California State PTA has a strong support for this bill. The closing the achievement gap is one of our highest priorities, and this is a bill that can help accommodate that. We're very, and I think all of you have letters of support up there. Being able to offer jobs to disadvantaged youth in all of the different categories that Assemblymember Fong iterated is critical to be able to help our disadvantaged youth stay in school, particularly when there's an educational component associated with the work. And we feel that the program fits in well with the Multiple Pathways report and Multiple Pathways activities as well. So we urge your support. Thank you.
Thanks, Nancy. Chris?
Mr. Chairman, members, Chris McKaylee on behalf of the California Alliance of Boys and Girls Clubs. And as you know, we have over 500 sites statewide and do a number of programs in terms of youth workforce development and serve a lot of students like Michael, and urge your support of the measure. Thank you.
Thank you.
Jennifer Snyder on behalf of the California Alliance of Child and Family Services, representing 1,000 foster care agencies throughout the state, and think this is a great bill for foster kids.
Okay. Any opposition? Yes, Nancy, you left something behind. I have a couple questions. Mr. Fong, as you know, this is an area of interest to the pro tem. So how does this bill build upon the efforts negotiated by the Senate in last year's budget to utilize WIA summer funds, youth funds, to help address the issues of high school dropout retention? Do you have any?
I don't have an answer for that, but
maybe the sponsor does.
We actually have been talking with the Pro Tem's office, and they wanted to ensure that we had an academic enrichment component in the bill. We also added in career pathway language. We need to do further work to define what that means, because we don't want to have the providers saddled down with new requirements without their input. So we're going to be working to define what that means. But just for example, we hired 3 summer youth ourselves at the California Workforce Association. Our site supervisor worked with them every single day to review the work that they were doing, and they were calling and interviewing other youth providers to find out the kind of experiences the youth were having in their programs. And so they would write up one-page sheets, and she would sit down with them and literally go over grammar with them. So that could be considered an academic component. That wouldn't be a career pathway component. So we really need to have some models in place and further define that. And we're talking about putting together a group of folks to do that.
Good. And would this bill prevent future use of the funds for similar purposes? I'm not sure.
I'm not sure I understand the question.
Okay, we'll talk to the powers to be in the Pro Tem's office. I guess sufficient to say that we hope before this gets to appropriations, you'll have discussions with the Pro Tem's office, obviously, and to the floor, so it will be successful.
Meeting with them later today.
Good. I have one more question. What's your major? Please don't say political science.
My major is business economics.
So you will be Bill Gates, but I won't make any comments on Bill Gates. Well, Michael, truthfully, you did a great job. I mean, you have a presence to you, and I hope you stay in touch, because we look forward to seeing you do great things in your lifetime, as you already have. Thanks for coming today. Mr. Fong, you want to have any comments in closing?
Well, thank you for the outstanding spokesman for this bill, Michael. And it will also enhance career technical education in our education system as well. So I urge an aye vote.
Thank you, Mr. Fong. Is there a motion? Senator Leno, we'll call a roll.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, Duchenne, Hollingsworth, Leno?
Aye.
Leno, aye. G? G, aye.
You have 3 votes. You need 1 more to get out, so we'll leave it on call. Thanks again. Next presenter is Mr. Arambula. And after him on the sign-up sheet, at least, is Mr. Nava or whoever appears.
Mr. Chair?
Yes.
Just to clarify that under penalty of perjury issue.
You're not under oath, Mr. Leno.
Just checking with public safety staff, I should have asked the question if this creates a new penalty of perjury authority. If it doesn't, then it's not a concern. And if it does, we could suggest some alternative language to provide a civil remedy for someone who provides false information.
Thank you. Technology is a wonderful thing. Welcome, Mr. Arambula.
Thank you, Mr. Chairman.
And you are presenting your AB 1827, number 6.
Yes, that's correct. Thank you, Mr. Chairman. Thank you, members. AB 1827 would direct EDD to staff one comprehensive one-stop center in each of the workforce investment areas with personnel that is trained to assist or to help unemployed workers in filing their unemployment insurance claims and, more importantly, in resolving unemployment insurance benefit problems. This measure would put knowledgeable people, knowledgeable staff, all federally funded, in the one-stops to actually help people with their unemployment insurance. I won't belabor the point that we all know there have been many problems with the Employment Development Department and the unemployment benefits system. They have been discussed at length in numerous prior legislative hearings. Suffice to say, this bill is intended to help deal with a service that's provided by EDD and actually make it work for people. The services to be provided under this bill are entirely federally funded, and I should point out the bill sunsets in 2014 when EDD's computer system, we are told, should be completed and operational. And there are several witnesses here, Mr. Chairman.
Go ahead. Welcome.
Thank you. Sheila Holmes, EDD Job Services, also known as Workforce Services. We are the public face for unemployment insurance, but we don't really do that work. So for the past 30 years, I've worked for the department. I worked when unemployment and job services were together. They're no longer together, and unfortunately, people are having problems that need to be handled face-to-face. So they flood in to see us and also to our WIA partners. The problem is we're supposed to be helping people find jobs. The 2.3 million unemployed last month need our help. We're not there really to do unemployment. So I noticed your brief offers some in-person assistance for filing a VUI. We don't. We can point to the phone, we can point to the computer, and that's pretty much all we can do. So it's not really a service to the customers, and there are some simple fixes that could be done with the right people.
Thank you.
Good morning. My name is Aida Canonizado. I'm from San Diego, EDD Unemployment Insurance. I've been there for 33 and a half years. And a lot of the services that this bill would be assisting in is things that are repetitive attempts to contact the call centers. And they are such things as they need to present identifications that they can do in person. When we need check stubs, they can bring them. By having a face-to-face meeting, instead of depending on the mail going back and forth, if they're lacking forms, if they're lacking documents, if they incorrectly filled out their unemployment form, we can explain it to them instead of wasting time and delaying their check longer over and over again by mailing back and forth. So there's a lot of services that can be rendered. It would also relieve some of the telephone calls so those who are attempting to file for unemployment can get through. And there was a disfranchising when we separated and became call centers for people who are illiterate, who need assistance in completing their forms, and other businesses that have sprouted up because of the fact that they take advantage of the people who need assistance. So there's a lot of positive things that this bill would be able to accomplish in servicing the public.
Thank you. Thank you for your years of service. Other speakers in support?
Thank you, Sarah Flox from the California Labor Federation, and we support this bill. As you know, 2.3 unemployed Californians are trying to access their UI benefits. Also, there's questions about dealing with all the different federal extensions, and now with the lack of a continuation of the extension, dealing with what happens then. So there desperately needs to be people that the unemployed can talk to in person to answer their questions and not overload the system. So we support this bill. Thank you.
Thank you. Witnesses in opposition?
Mark Brigade on behalf of the California Chamber of Commerce. We're here in opposition to this bill. While the bill attempts to address the increased demand for assistance due to high unemployment, it doesn't guarantee any additional efficiency. And although the author indicates that these jobs would be paid for with federal funds, which is technically true, the funds that the employers pay go to the federal government and then come back to the state to pay for these employees. To shift employees to these one-stop shops or to these in-person assistance shops would merely supplant employees that we currently have in assistance right now. Our concern is that ultimately this could lead to either higher costs or actually less service than you've got now. I think we remember the old days of the DMV, going to wait in line for hours and hours at the DMV. The concern here would be is that once you got to the front, not only would it take months to train people to be there, if they weren't completely qualified to handle the issue that you had, you may, after waiting a very long period of time, get up to the front of the line and find out that your claim can't be adjudicated by this individual. In addition, the bill would require, simply by its very nature, that you have multiple employees at every location, simply based on things like vacations, meal and rest periods, those sorts of activities. To simply have one individual in a location is not secure, nor is it actually workable. We think that the funds should be prioritized to continuing to upgrade the outdated computer system and hire more employees for the call center. We also think moving from a centralized phone system brings with it the logistical challenges that I mentioned, and for those reasons, we'd oppose the bill.
Thanks, Mark. Anyone else? Any questions or comments from committee members? Okay, it's been moved. Any closing comments? You want to address some of the comments from the chamber?
Thank you, Mr. Chairman. First of all, I think it may have been a good idea to try to move towards use of computers, but it's been a difficult transition. That was aggravated by the downturn in the economy that in 1 month last year alone, EDD received 42 million calls that were unanswered. People were calling dozens of times in one day just trying to get through. And, as to the argument about it being inefficient, I think it's inefficient for the individuals to not get their unemployment insurance on time, to risk late payments or risk losing their cars or their not being able to pay their rent. I think it's inefficient, as EDD was doing, to pay millions and millions of dollars to a company that would provide a recorded message essentially saying, try again. I do believe that in the long run, it will be more efficient to rely exclusively or almost exclusively on the call center operation. But EDD itself readily admits that their computer system is not up to speed, that they're working on it. They've been working on it for a number of years. They've assured us in prior hearings that their new system should be up and running by 2014. That's why we put in the sunset. So this is an interim solution to deal with the multitude of folks that have been calling our district offices complaining about not being able to get through. And I would just end with this, Mr. Chairman. If we don't provide individuals to help deal with problems, then I think we're going to have to add a line item to EDD's budget next year for all the people that are so frustrated that they rip the telephone off the wall.
Well, I appreciate the bill, and I appreciate the comments, particularly from rank and file folks. We've all gone through the experience. I know my district staff is overwhelmed with phone calls, and it's not just the number of phone calls, but it's the level of anxiety by the people by the time they get to our offices. So, and it always struck me as odd when I was in county government that we, with much ballyhoo, opened these one-stop centers, did some good things in terms of culturally providing better performance, but they're really not one-stops, and for people to go there. And ultimately, what you really want, of course, is to get people reemployed, as our last speaker said. So they go to the one-stop, they get more connections with people who can actually help them with that. So with that, is there a motion to approve? Senator Leno, we'll call a roll.
Was this 2187?
Yes. I forgot you left the room, Rosa. I'm lost without you. 1827.
Oh, that was 1827?
Yes.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, Duchenne, Hollingsworth, Leno? Aye. Leno, aye. Yee.
All right. You have 2 votes. You need 2 more, so it's on call. Your next bill, Mr. Rambula.
Thank you once again, Mr. Chairman. I'm pleased to present Assembly Bill 2187. This is a measure to improve the prosecution of wage theft. What the bill does is it specifies that non-payment of wages must be willful, and the employer must have the ability to pay. In other words, the employer does not dispute the wages that are being owed. The employer has the ability to pay, but chooses not to pay. This bill puts together an improvement on the current law and applies it to those situations where an employer has demonstrated a willful theft of wages. Prosecution of this crime, of course, is at the discretion of the district attorney. And specifically, upon conviction of the crime of wage theft, the bill would impose a misdemeanor penalty punishable with a fine ranging from $1,000 to $10,000, possible county jail time. It would also result in full restitution to the victim equal to the amount of unpaid wages and no more. And it also gives the district attorney the opportunity to recover the costs of prosecution. In short, the bill gives district attorneys the tools that they need to prosecute theft of wages as the serious crime that it is. The remedies in current law are not sufficient, and this bill would help return to the worker wages that have been wrongfully and unlawfully taken. And Mr. Chairman and members, the opposition claims that this bill could make employers into criminals if they have legitimate wage disputes that take more than 90 days. That simply is not true. The bill specifies that the employer must willfully deny wages, and both labor code sections and court precedents make very clear that the use of the word willful actually protects employers while they are pursuing their legal rights, because it is simply not willful theft of wages if and while the employer is legally disputing the claim. Secondly, it's been argued that willful is a vague term that could trap honest employers. That, again, is simply not the case. The California Supreme Court, in its written opinion in the case of In re Trombley, said that the same identical language we use here in this bill, and I quote, does not make the mere failure to pay wages a crime, nor does it subject an employer to imprisonment who disputes in good faith an employee's claim for wages. So willful, Mr. Chairman, has been found constitutional in California since 1948, the date of the Trombley case. It's been argued that the bill would hurt the state's job environment, and what I would respond is, once again, no. The bill protects the vast majority of employers that are honest and law-abiding, and that currently suffer from a competitive disadvantage, having to compete against the few that cheat and steal wages from their employees. Finally, it's been argued that innocent employees could get caught up inadvertently. Again, no. Only the actual person that makes the decision not to pay wages is liable. The provisions of the bill only apply if the employee is the individual who knowingly and willfully steals an employee's wages. If the person is simply following directions, such as a bookkeeper, this bill would not apply to them because there has been no criminal conduct on their part. I've discussed briefly what the bill doesn't do. Now, I'd like to discuss very briefly what it will do. What the bill will do is to encourage prompt payment of wages. It will help district attorneys prosecute theft of wages cases, and it will make sure employees receive full restitution of unpaid wages. The bill will strengthen the enforcement of existing labor laws. For those bad apples who willfully fail to pay wages owed and have the ability to pay, this is an appropriate remedy. And finally, as the California Supreme Court said in the case In re Trombley, enforcement of wage theft is essential to the general public welfare, especially given the position of the average worker and their dependence on wages for the necessities of life. With that, there are two witnesses here who would like to address the committee.
Good afternoon.
Yes, good afternoon. My name is Victor Naro. I'm a professor of labor studies at UCLA. I'm also the co-author of this report, Wage Theft and Workplace Violations in Los Angeles. I think the findings in the report is well articulated in your committee analysis. I just want to point out two major compelling data in this report that highlights the need for this type of legislation, such as AB 2187. Every week in Los Angeles, low-wage workers suffer at least one pay-based violation at an average loss of 13% of their weekly wages. When you add up all these violations, low-wage workers every week in Los Angeles lose $26.2 million a week in wage theft violations. And you can only imagine what this does to the local economy in Los Angeles. These are the compelling data that's highlighted in this report that really shows the need for this legislation. And our policy recommendation really asks this body to consider this kind of legislation to address the growing crisis of wage theft in major cities throughout California. Thank you.
Professor.
Mr. Chairman and members, Mark Schock, California Rural Legal Assistance Foundation. This week I've got the chart responsibilities, and we've handed out a chart that compares the wage-related criminal penalty provisions of the Labor Code and the Penal Code. And the purpose of this statute is to fill a gap in California's criminal laws, which allows an employer to continue to not pay wages without suffering any additional criminal penalty. The bill would, in effect, define theft of wages against an employee who quit or was discharged, the failure of the employer to pay those undisputed wages within 90 days of them becoming due. In looking at what would be the appropriate minimum, maximum, and related kinds of remedies that should be available in 2010, we looked at all of these statutes, and most of them are statutes from the 30s and the 40s that have never been amended since, but a few of them have been enacted more recently. And so, for example, the minimum fine of $1,000 for this for this violation imposed by the Arambula bill, you'll see on page 2 that the only, in column 3, the only statute that provides for a minimum $1,000 fine is one that was enacted about 15 years ago.
Similarly, in column 4, the maximum fine of $10,000. On the bottom of the first page in the fourth column, the maximum fine for failure to comply with equal pay requirements of $10,000 is a fine level created in 1992. So we think we created a set of fines and penalties which are in the mainstream of what California has done in the last 20 years. And we think this is a modest improvement over existing law, particularly with regard to the issue of restitution, which this statute requires full restitution of all unpaid wages. The Victims Compensation Act of 1982, which was a constitutional amendment here, which was implemented by Penal Code 1202.4, requires restitution but allows a court to award less. So in the cases of wages, which we think is a grave public offense, there ought to be no opportunity for reduction, and this bill would require full wages to be paid for the workers.
Thank you.
With that,
that's good. Other witnesses in support? Caitlin.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. What we do know about existing labor law enforcement is that it isn't working. There is not enough of a disincentive to make employers follow the law, particularly when it comes to vulnerable workers, when it comes to low-wage workers and immigrant workers, and really in this economy, what workers are not vulnerable. And so we think that it is essential that we start trying to come up with ways to create a real financial incentive to pay workers what they are owed. We just heard a few minutes ago from that very moving testimony from a young man about his family going through homelessness. What do you think happens when workers are willfully denied the wages from a job they no longer have for more than 90 days? People's lives fall apart. People do lose their homes, and their whole lives are disrupted. So that's a very serious action for an employer to take, to willfully, not accidentally, deny the wages that a worker has worked for and earned and counted upon to support their family. So we think that this is a reasonable bill and a very important one. Thank you.
Deanna Furman on behalf of the California Nurses Association, also in strong support of this bill.
Thank you, Deanna. Witnesses in opposition?
Mark Brigade on behalf of the California Chamber of Commerce. We do oppose this bill. I think we have some a difference of opinion on what the definition of willful means, and I know my counterpart will discuss that later. But oftentimes there could be disputes on what money is owed. Oftentimes, if you have to go to labor commissioner determination, that could take longer than 90 days to get that resolved. That could put you into a situation where you would, under this bill, be criminalized. This bill could also be construed to criminalize any wage dispute. I know I mentioned meal and rest period previously, but to bring that up again, these are, meal and rest has can go back as far as 3 years. This could be construed to fall under a very similar situation as that, where you could come in and say that those funds were willfully withheld. And also, the author had mentioned that this does not go in and criminalize employees. However, we do believe that agents and employees are subject to liability in the bill. Our read of it says that this could make all employees in a payroll department and all the way up the supervisory chain criminals under this act. As a matter of fact, in the bill, it indicates an employer or other person acting either individually or as an officer, agent, or employee of another person is guilty of a misdemeanor. This is pretty significant, especially when this could be a legitimate wage dispute. And with a legitimate wage dispute, you could find yourself in over 90 days. We just feel that the bill is written far too broadly, and for those reasons have to oppose.
Okay. Mr. Belote.
Mr. Chair and members, Mike Belote for the California Employment Law Council. I want to be very, very precise here because the author and supporters have quoted this court case that talks about willful. We spend a lot of time in the legislature debating the term willfully, and if in fact this court case stands for the proposition that a good faith dispute does not create a willful failure to pay, then that ought to be clarified in the bill, it seems to me, so that we don't get to people who really disagree about whether the wages are in fact due on a dispute that goes over 90 days. But I wanted to speak to another part of the bill, and I was struck by Senator Yee's comments about, obviously, this being the last policy committee. This is the last chance to look at what the bill actually says. And I wanted to speak to a portion of the bill, and I have spoken to the sponsors about it, that in addition to the remedies provided in current law, we have restitution, and I should think no responsible organization would oppose the restitution obligation. But it allows for the defendant to be assessed the reasonable costs of prosecuting the crime. Now, we are not talking about a civil action here. We are talking about an issue where it would be the people versus DeSaulnier or whoever, where the people, the district attorney, brings the action on behalf of the people. And this is a very unprecedented situation to allow the defendant to be assessed the reasonable costs of his or her own prosecution. And I'm not sure exactly what reasonable costs would be. Does that include the district attorney's time, the investigator's time, perhaps the judge's time, the jury's time? We could debate that endlessly, but it seems to me that that is a public safety question of very great moment when we start suggesting that the defendant should get a bill for his or her own prosecution. It was suggested that this is a very, very serious crime. And obviously, if somebody willfully fails to pay wages that they know are due and are undisputed, that is a serious crime. But we have lots of heinous crimes here in California where we don't send the defendant a bill for the prosecution that creates the criminal penalty. And so I think that is a step far too far and ought to be evaluated very, very carefully, because pretty soon we'll be sending all defendants a bill for their own prosecution because we have decided the activity is disfavored. It may, and I understand your job is not constitutional, but it may even be unconstitutionally vague because it is putting a penalty on a person where we can't define what it is. We don't know what the reasonable costs of the prosecution are. So for those reasons, because this is the last policy committee on this bill, we would ask for a no vote until and unless these problems are resolved.
Thank you.
Mr. Chairman, Senators, Julianne Burrell, here on behalf of Associated Builders and Contractors of California. Very briefly, we agree with the comments made before and ask for a no vote.
Good afternoon, Mr. Chair, members. David Vandergriff on behalf of the California Hospital Association in opposition.
Mr. Chair and members, John Hanley, California Independent Grocers Association, in opposition to the current form.
Let me kick me on behalf of Western Growers in opposition.
Okay. Questions, comments? Yes. You want me to start?
If you could please respond to that.
The last point?
Yes.
Well, 2 points of clarification. One, obviously the reasonable costs of prosecution would only apply in the case of a defendant who is found guilty of the crime. Okay? And it's built by analogy with a bill that this committee passed last year and the governor signed, which allows, in the case of farm labor contractors and garment contractors who failed to pay a judgment for wages, to be essentially taxed the cost of enforcement against them by the Division of Labor Standards Enforcement. So it's analogous to that. The public costs of enforcement shall be borne by the violator.
But was that a criminal conviction?
That was civil.
So do you have any precedents for this?
The only precedent that I know of by analogy is the notion that personal property is forfeited in a number of cases, and I can't point to a specific penal code criminal provision that is analogous to this, but that shouldn't stop us from taking a good, firm step forward.
But for grand theft, for armed bank robbery or serious crimes.
Well, I don't want to be facetious about this, but the way things are going in California, a lot of state functions may end up being paid for in part by violators. And as to what is reasonable, this is an issue that's been raised with district attorneys with us when we've brought cases to them in rural California wanting prosecutions. And they have raised the issue of the cost of prosecutions and how they have to internally, decide where to spend their limited dollars. And this is an effort to address the cost issue on the local level where most of these prosecutions would occur. And again, it's aimed at someone who's determined to be guilty of the crime.
Can you answer some of the questions that Mr. Belote raised, as in what are reasonable costs? It's the district attorney's
I can, Senator. Judges have a great deal of discretion in other types of cases to assess attorney's fees. They have a number of factors based on, on previous cases on common law as to what is permissible and not permissible. So this bill would entrust judges to make the same kind of determination in this setting.
I'd be interested to hear the chair's thoughts on this new precedent. Because I'm not. Yeah. It's new, and I realize that with ever shrinking public funds, that this may be a direction we're going in. I just wonder if we want to do this in this bill.
And really many decades of us trying in unique cases to get local prosecutors to bring these cases. And there are a number of concerns that they've raised that the bill addresses, including the lack of a minimum penalty, the lack of a penalty that is high enough to indicate the gravity of the offense. So the bill really tries to address all of those. And
I guess I apologize where I know that there are authors waiting. I'd like to get through the agenda, but we have had, I think, some fairly significant and healthy public policy discussions today. So forgive us for actually being adherents to that. I don't think either one of us would hesitate to support the goal of it. I mean, who amongst us don't want people who aren't paying minimum wage willfully to be penalized? So this goes in the same sort of consistent theme we're having today, is how do we focus on the people who are really bad operators in an effective way. And effective means cost to everybody. And this is something I'd like to have an ongoing discussion with some of your opponents about that's consistent with the other discussions we've had. So I'm just sitting here thinking, as a former employer with a very small profit margin, who I always, when someone left the door under unpleasant circumstances, we made sure they were paid when they walked out the door. Now, there were instances where we had disagreements about that I might have considered disputing, but to be perfectly honest, frequently I just thought it was easier to write the check, and this was in a generally low wage position. So as an employer, I'm just thinking as someone who thought, absent Mr. Belote's comment about the people versus Mr. DeSaulnier, I always tried to avoid that, not for political purposes, but just as a cost of doing business. So I'm thinking about also, it goes consistent with we want to get after people who aren't doing the right thing, whether they be employers or employees. So I'm afraid of the employees, who will take advantage of this as well, for small business owners who are trying to do the best thing. And then the other discussion about the broad definition of willful. So we're both free thinking here, I think, and have legitimate concerns. In terms of...
Can I just jump in and make one quick point?
While I still have a stream of consciousness before I forget. If you had some kind of language that at least allowed for, if you have a case pending in front of the Labor Commission or the Labor Board, would at least alleviate that, knowing that it might invite bad employers to use that. But if you're paying low wages, just intuitively, it doesn't strike me that you would go to the Labor Board or the Labor Commission to avoid paying something fairly small.
At the risk of interrupting your stream of consciousness,
it may not
Mr.
come
Chairman,
back, Mr. Ram. That could be a good thing.
The intent has always been, and I've expressed this in prior policy hearings, the intent has been that the 90 days only begins to run once if there is a dispute, whether it's the labor commissioner or elsewhere. The 90 days does not begin to run until that dispute is resolved. So essentially what this bill would do is it would say to an employer, you had a dispute, you had your chance to contest or to address that dispute. That is resolved. The employer is liable, and the employer then has 90 days to make payment on essentially what is a judgment.
So could you, is that in Section 2? I'm looking at lines 21 through 23 on page 2. So willfully fails to pay all wages due to an employee who has been discharged or who has quit within 90 days of the date that those wages become due. So maybe we need to clarify.
If the committee wishes, we would be happy to make it very explicit that the 90 days, failure to pay all wages within 90 days, that only starts until the point where the dispute has been resolved or there is no longer a dispute. Can we do that? That'd be all right with you? That certainly would bring me some comfort level. That's been our intent, and I would be happy to clear that up.
Well, all due respect to attorneys, we don't want to give any attorneys more business unnecessarily.
That's what the language became due means. It's a term of art under the Labor Code, and we chose this language. It's identical to language in a related statute, which we tried to put this bill into, and Ledge Council decided to put it here. But the language carried over exactly. The willfully failed to pay, having the ability to pay, when due, that's the language of the 1948 Supreme Court decision and all subsequent cases that have followed that decision. And this is not a private right of action. This is the employee can't jerk around the employer. We've had, I'll give you an example, we've got approximately 30 judgments in Fresno County right now that we've been unable to get the DA to pursue involving $250,000. So no employees going to the DA and getting him to bring a case over his individual claim.
That's your point. Point well taken. Any other comments or questions? I guess we're both...
I'm still struggling with the first 5 lines on page 3. If you want, we've got a conviction of misdemeanor. We've got $1,000 to $10,000 in fine, and that's going to be multiplied by 270% because of all the assessments that go along with the misdemeanor fine. So the $10,000 becomes $37,500. But I don't see how we're this is precedential. So then why should someone convicted of this misdemeanor be paying court costs in a criminal case, but someone who commits a felony doesn't?
Of course, we think this crime should be a felony, but for reasons that we both understand, it's not.
But then again, if you want greater penalty, I would put it more in the fine, and then not more than 6 months. If you want to get more severe, go to 12 months. But to go down this path of, in a criminal case, having the convicted pay the court costs, that just, I would really want to get the take of my public safety staff to see if
Mr.
that's
Chairman,
a wise thing to do. I don't, on first blush, think it is.
And since you have the chair of Public Safety Policy Committee and the chair of the Fiscal Committee, how are we going to get DAs to prosecute these? You already brought that up.
Well, Mr. Chairman, if it would help, I think having the reasonable costs of prosecution is a helpful element of the bill. But if that causes concern to the point that you would not be inclined to support the bill with that provision, I would be willing to remove that provision. I think the other elements of it are a good step forward. I think it would be helpful to provide district attorneys with the ability to recover their costs. The cost would not go to the worker. They would go to defray the cost of prosecution.
But they don't have the cost.
But that's the job of a district attorney, to prosecute crime.
Well, and that's why I would be willing to remove that provision.
I think that would be wise. I don't argue this is a crime. This is theft. It should be a misdemeanor. It should have fines associated with it and or potential time in jail. But this other aspect of court costs is something else. So I won't argue it further. You've already accepted. I thank you for that.
I think both of us are, the spirit of the comments are just struggling with what we know you've already struggled with. We want this to be effective, and we want to be effective for everybody. So you've made some commitments, Mr. Arambula. I would like to. My staff's going to really kill me for making these commitments to continue, but to the degree we can have another conversation. This is not directed to you, but if the opposition gets the general sympathies that we're all in agreement that we're trying to make we're trying to make all of the laws effective in a world where more bad employers seem to be doing bad behavior, which disadvantages good employers as well. I think we're all ears to suggestions as this goes to approps, and then maybe off and onto the floor. So I'd be willing to work with the author and the opponents and the supporters in that spirit.
I appreciate your offer, Mr. Chairman, and I readily accept your offer of assistance. I would just point out that we have raised the issues that have been discussed today at each of the policy hearings. There has not been anyone willing or forthcoming to try to resolve them. And as I pointed out in my comments, the claims are simply not accurate. And if there is something that we can do to include language in the bill to that effect, to clarify any misunderstanding, we'd be happy to do so. We've been happy to do so from day one. And, sometimes folks want to roll the dice and they want 100% or nothing. I think we're trying to work in good faith to come up with a solution that will help deal with a growing problem.
You're always an independent and thoughtful voice in this institution. Is there a motion to move to appropriations?
So you'd prefer that the amendment be taken in approach?
I think that probably be more efficient for purposes of today.
Yes.
You have my full commitment to do so.
Sure.
We can trust this gentleman in spite of his lack of party affiliation. Or maybe because of that. A motion by Mr. Leno to move to appropriations with the understanding that there'll be further discussion and amendments.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, Duchenne, Hollingsworth, Leno? Aye. Leno, aye. Yee.
Thank you, Mr.
Thank you, Mr. Chairman. Thank you, members.
Sorry to torture you.
Oh, it's been a helpful discussion.
Mr. Nava, speaking of torture.
I have a non-intellectual, non-controversial bill. Exactly a little respite that you need.
And then we'll be followed by Ms. Lowenthal.
This is AB 2364. Will ensure that the California qualifies for $559 million under the American Recovery and Reinvestment Act. The available funding is part of the federal unemployment insurance modernization provisions to encourage states to adopt various unemployment insurance eligibility provisions that meet their guidelines. A review by the United States Department of Labor in May of 2009 determined that our current law may render California ineligible for federal incentive funds. Presently, a person may qualify for benefits if they left their employer to protect his or her children or himself or herself from domestic violence abuse. This bill will bring California into compliance with federal guidelines for good cause for an individual to leave an employer for domestic violence and qualify for unemployment insurance benefits by changing but one word in the Unemployment Insurance Code from protect his or her children or himself or herself from domestic violence to protect his or her family or himself or herself from domestic violence abuse. By making this change, California becomes immediately eligible for the $559 million under the American Recovery and Investment Act. Ask for your support, and we have witnesses in support as well.
Witnesses in support.
Yeah, this is Greg Riggs with the Employment Development Department. This is an administration-sponsored bill. It does make a very minor technical change that allows us to qualify for the $559 million in federal funds. So we ask for your aye vote. Thank you.
Other witnesses in support.
Sarah Flocks from the California Labor Federation, and we support this bill both for the federal funding but also as a matter of policy to allow people to be able to leave abusive situations. Thank you very much.
If we can make some space, that'd be great. Hi.
Good morning. Mary Weiberg, Commission on the Status of Women, in support of this bill.
Thank you. Anyone in opposition? Moved by Mr. Leno. Would you like to close the ever articulate?
Respectfully ask for an aye vote.
Just a general question for the department. We've had discussion about just being able to enforce these kind of provisions. Do you feel confident that you'll be able to, given all the pressures on you right now?
Yeah, this is a very minor change, and there are actually very few eligibility cases that boil down to this. So this would not add a significant workload at all to our department.
Okay, well, we'll take you at your word. There is a motion. Call a roll, please.
Senator DeSaulnier.
Aye.
DeSaulnier, aye. Excuse me. Wyland, Duchenne, Hollingsworth, Leno.
Aye.
Leno, aye. Yee.
Your vote has 2 votes. We need 2 more. We'll leave it on call. Thank you
very much.
Planning to continue going nonstop.
What do you think? Ms. Lowenthal, you're next. Sure. Watch out. Good afternoon. Welcome.
Good afternoon. Thank you so much, Mr. Chair and member. AB 2726 will help connect job seekers to good-paying jobs and lasting career pathways. The first component of this bill simply clarifies a gap in understanding and is consistent with guidance letters from the U.S. Department of Labor. It makes clear that apprenticeships qualify as job placement in addition to training. The second component of this bill ensures better connection between workforce partners. The ultimate goal is to connect job seekers to quality training that leads to lasting careers. The Department of Labor tells us apprenticeship opportunities can and should be integrated throughout the workforce investment system as a means of leveraging resources across systems to better serve regional needs. This bill would provide that key integration among workforce partners so we can make the best use of our workforce development dollars. Because when we connect people to state-approved apprenticeship programs for projects in the building trades, they're not just getting an immediate job placement, they're getting a pathway into a lasting career. This bill is sponsored by the State Building Construction Trades Council of California, and Cesar Diaz is here with me to answer any questions. I ask for your aye vote.
Thank you.
Thank you, Mr. Chair. We're sponsoring this legislation. There's a unique attention that construction is receiving under ARA funds and just in public works in general. There's a lot of money that's out there, hundreds and hundreds of millions of dollars that have gone towards community colleges and workforce investment boards in a sense to train people and get them prepared for the jobs of the future, and currently, of course, the jobs that will be available fairly soon. This bill seeks to ensure that they don't miss apprenticeship as an opportunity to partner with apprenticeship programs, which are scattered all throughout the state. It's about 250 and 15 apprenticeable crafts. This ability will allow them to leverage private dollars with public dollars and maximize the benefit for the taxpayer, in addition to giving the individual the opportunity to move on into more specialized training and actually access a career in construction. So for these reasons, we wanted to ensure that there's a partnership at the local level. And the local levels can, at the local workforce investment boards with the apprenticeship programs, they can determine what that partnership would be. So they have the flexibility to actually make that happen there. But from the state perspective, they should be integrating these programs together. And for those reasons, we ask for your vote.
Thank you, Cesar.
Mr. Chair, members, Christy Baumer, representing the California State Pipe Trades Council and the IBEW, in support of the bill.
I'm confused. Other witnesses in support?
Sarah Flocks from the California Labor Federation.
Does that mean you work for which now? No, never mind.
And we are also in support of this bill. Thank you.
Agreeing with the State Council of Labor is in strong support.
Thank you, Patrick. Any witnesses in opposition? Would you like to close?
I respectfully ask for your aye vote.
Okay. When I get someone back, we will have a vote. Good bill. I'm fully supportive.
Thank you so much.
Let's see, Mr. Bradford. Oh, Mr. Block. I'm sorry. He's just been so patient so long, and I saw you walk in, Mr. Block. I apologize.
No problem.
Item 9, AB 2058.
Yes, thank you, Mr. Chair. AB 2058 will make it easier for unemployed Californians to access unemployment benefits while in the process of training for new or upgraded skills for jobs. The whole purpose of the training, of course, is to make someone more eligible and more likely to gain employment. And I was shocked, actually, in November when I was visiting a career center in my district when two of my constituents came up to me and said that they had been in training programs trying to develop skills so they could get back into the workforce, and they were cut off of their unemployment. We did a little bit of investigating, and we found out that EDD, which is required under current law to approve job training, EDD was taking up to 8 to 10 weeks to do the verification of employment. And frankly, not their fault. Their workload, their volume had expanded so greatly in this terrible economy with so many people unemployed that it was just taking a long time to do what normally they could have done in just a week or two. As a result of this time period, people were losing their unemployment benefits while they were on job training before the training was approved. The result of that is that these two people I talked to were leaving their job training because they needed to get back on unemployment. Others in my district weren't taking advantage of excellent training opportunities because they feared the same thing would happen to them. If they went to training, they'd lose their unemployment. As a result, my bill, AB 2058, does three things. The first is it calls for automatic approval of certain types of training that's already been approved by the Workforce Investment Act, the Employment Training Panel, CalWORKS, the Trade Adjustment Assistance Act. Those lists of training have been modernized, and then also the eligible training provider list has been added. And if your training fits any of those categories, it will be automatically approved by EDD. So you don't have this 8 to 10 week waiting period where you can lose your benefits. A second type of training which is not on any of those lists, but which is clearly tied to potential jobs in the future, training to make you more marketable, workforce training, that does have to be approved by EDD, but because this first category of training is now automatically approved, EDD feels it could do the second type of approval much more effectively, efficiently. They could expedite that so people wouldn't lose their benefits. They could be approved for the second type of training within the week to 2 weeks that normally occurs. Then there's a third type of training, which is more general education, which does prepare somebody for the workplace, generally make them more marketable. This third type of training would only be approved, it still has to be approved by EDD, and would only be approved when the federal government underwrites the training. So no state funds would go to this third type of training. And under federal guidelines, this is training the federal government feels is important when someone is unemployed, that they be able to make themselves, again, more marketable generally. Right now we talk all the time about jobs, and jobs are critical to the state, but it's going to be critical as the state creates more jobs that we have well-trained, skilled workers to take these good jobs of the future. And what this does, it says instead of people staying at home while they're unemployed, spending a little bit of time looking for jobs and basically wasting time, this says we've got to get people trained so they can get back to work as the economy improves. And 2058 is the way we do that. The bill is sponsored by the California Workforce Association and the California Federation of Labor. It's supported by Goodwill Industries, the California Professional Firefighters, California Nurses Association, AFSCME, the Community College League. And important to also note that with amendments that we've already taken, California Manufacturers Technology Association and the California Chamber have gone neutral on the bill. They've taken off any opposition. And I've got witnesses here to testify. Jennifer Mitchell from the California Workforce Association. And you're not Angie.
No, I'm not Angie.
So if you will go ahead.
Thank you. Thank you. Thank you, Assemblymember Block, for carrying this bill. And it's now afternoon, Mr. Chairman and friends. As a sponsor, co-sponsor of this bill, we know that you also have a similar bill in the Senate, and we'd like to thank you for your leadership on that bill. We're working with the staff who are working on that bill, also with the folks who have been opposed, to bring them to neutral. I want to recognize the gracious work of the Employment Development Department to try and fix this issue to the best of their ability without statute, and have been gracious also in providing technical assistance to us. I think you may have heard these numbers before, and this is just in relation to the Workforce Investment Board executive directors who have been hearing about this problem in your districts. And so 92% of them reported hearing that their customers' benefits were being suspended because of this issue, because they were in training. 52% reported customers have dropped out of training because of this issue, which really has affected training providers as well. So 48% reported that their training providers are being impacted, including the community colleges, and 8% reported that classes are going unfilled, being canceled, or postponed. So this is a huge issue. It's bipartisan. In the Assembly, I'm happy to report that we did get bipartisan support, and so are grateful for that. Hope we will have it in the Senate as well. And with that, I will turn it over to our other co-sponsor.
Thank you.
Thank you to the chair and the committee, and thank you to the assembly member. This is Sarah Phlox, not Angie Way, from the California Labor Federation, and we are a proud co-sponsor of this bill. As we know, when California starts to get out of this economic crisis and we have recovery, we need to get people back to work right away. There's 2.3 million unemployed Californians. And we want to make sure when employers start hiring and we start getting back on the road to economic well-being, that people are trained and ready to go, and at day one are able to get into a job. So this bill is going to remove a lot of the barriers that allow people to collect their unemployed benefits, to survive, to be able to make payments on their house and their cars and have health insurance, while at the same time they're getting the training that they need so that they can get a job either in the green economy or in other kinds of growth sectors. And also just to mention that at the federal level, DOL has issued several guidance letters regarding retraining, and they've recommended that during this economic downturn, when we have such serious levels of unemployment and there's such high levels of long-term unemployment over 6 months, that it is critical that we open up training programs so people are able to get the training while they're suffering from long-term unemployment. And so this bill will really bring California into compliance with the recommendations at the federal level. And so we would urge your support, and thank you very much.
Thank you. Mr. Block, anything in conclusion?
I just ask for your aye vote.
I forgot to ask for opposition, but since you've done such good work, Mark, I just want to... You can come and say you support it, or you're anxiously ambivalent or enthusiastically ambivalent.
Don't often get this opportunity, but I do want to make sure and get up and say we worked very closely with the author. They were very generous and gracious to work with us and come up with some amendments that work for all parties involved. And based on that, we are removing our opposition.
Okay, great. We appreciate that. Thank you.
We may have some support in the room, too. I don't know if you want to hear that.
Does anyone else want to support? We all support you a little. All right, thank you.
Thank you.
As soon as we have some members back, we will raise a question. Let's see. Mr. Bradford, finally. I'm going to ask witnesses on both sides. Hopefully we're well behind. We had a lot of time in policy discussions. This will be the kiss of death, but I think we're past our controversial bills, so if witnesses on either side can be as brief as possible so we can try to get all of these assembly bills out of committee today, that would be helpful. Mr. Bradford.
Thank you, Mr. Chair. I ask for aye vote. I'm here to present AB 2188. AB 2188 incorporates several guidelines from the U.S. Department of Labor for states to consider when moving toward an electronic delivery method for benefits, such as restricting fees and guaranteeing access to customer service offices. The goal of the bill was to establish a model that the ADD could follow that would incorporate those guidelines and provide strong protections for consumers. As the analysis actually states, last month EDD finalized its contract with Bank of America for electronic payment of benefits for unemployment and disability benefits, which far exceeded my expectations and provides a level of protection for consumers that cannot be found anywhere else in the nation. Following that development and review of the protections in the contract, I've agreed to remove unemployment benefits provision from AB 2188 in the Appropriations Committee. As amended, AB 2188 now only applies to disability insurance and authorizes EDD to move the electronic payment method for recipients of those benefits. I respectfully ask for your aye vote. I'm here today with California Labor Federation in support of the bill.
Comments?
Sarah Flocks from the California Labor Federation, and we are a co-sponsor of this bill. EDD has followed a national trend and moved towards eliminating paper checks and gone to direct deposit and to issuing electronic pay cards. And initially, we wanted to make sure that all the protections were afforded to recipients who are getting their benefits on pay cards, and that there were no very costly hidden fees that are going to be eating up the benefits that they were paid. And so we worked with the Assembly member to put together this bill. EDD has done an excellent job in getting a contract that offers all of the protections that we could have wanted, plus probably has more protections than most of us have on our debit cards in terms of making sure that recipients of UI and DI don't have any fees that are eating away at these benefits that are so important at this time. And so we strongly support this bill and would urge your support as well. Thank you.
Well said. Any other witnesses in support? Any witnesses in opposition? Good job.
Thank you.
And you're going to take up Ms. Bass's bill.
Yes, Mr. Chair, thank you for allowing me to present 2696 on behalf of Speaker Emeritus Bass. The Green Collar Job Council, created by AB 3018 in 2008, works to develop a comprehensive array of programs, strategies, and resources to address California's growing need for a highly skilled and well-trained green workforce. AB 2696 helps the Council in its work to develop a strategic initiative to meet the needs of this emerging green economy. AB 2696 authorizes the California Workforce Investment Board to accept revenues, monies, grants, and goods and services from federal and state public entities, philanthropic organizations, and other sources to help implement the green strategic initiative outlined in the Green Collar Jobs Council. AB 2696 provides another tool to coordinate investment opportunities during these challenging economic times. With strategic initiatives in place, the Council will be better prepared to target specific areas of need and coordinate resources for training in the green economy. This sector supports those efforts. I respectfully ask for your aye vote.
Thank you. Witnesses in support?
And we took the amendments to this. Speaker Emeritus took the amendments that were offered up.
Great. So there are 4 amendments, and you took them all.
Yes.
Thank you.
Jennifer Mitchell, California Workforce Association, in support of this bill.
Thank you. Any other witnesses in support? Witnesses in opposition? Great. So we will hear it when it comes out. Good job. Before you leave, Assembly Member, on AB 2188, you were going to take an urgency clause to add Mr. Nilo. Was that right, as to the bill on your previous bill? Not on this bill.
As a co-author? Yes.
Yes.
Mr. Nilo, yes,
Okay.
co-author, yes.
All righty. Thank you. Just wanted to clarify.
All right. Great.
Since we weren't clear, you and I, neither of us were clear. We're now clear.
We are clear
as
now.
long as staff is. Thank you very much. Mr. Cotto.
Thank you, Senator, and members of the committee.
I see you have the pipe trades with you today.
This bill, AB 2253, recognizes the very real increased risk of job-related cancers that are contracted by our state's firefighters and other public personnel. This bill simply extends the cap of the existing cancer presumption statute of limitations from 5 years to 10 years. This will provide more protection to firefighters and their families who face the risk of latency periods of those types of job-related cancers. You'll note that the bill has significant bipartisan support, some 7 Republican and 15, as I remember, Democratic co-authors. Here with me today is Christy Boma from the California Firefighter Association.
Mr. Chair, Christy Baum with the California Professional Firefighters, sponsors of this bill. And I'll just make a couple points. The legislature nearly 2 decades ago decided that studies demonstrate that there is a direct link between cancer and firefighting. Studies have continued to be released to confirm that finding. And so this bill doesn't do anything to affect that. It only deals with another issue that has been demonstrated in study after study after study, which is the latency period from when the exposure happens and then the actual mutation of the cell and the cancer developing is at minimum sometimes 10 years. So the minimalist view that you are taking and my author is taking in this bill to move it from 5 years to 10 years just respects the data that is out there about latency period of contracting cancer. But I will also remind you, finally, and it was just affirmed in a January Work Comp Appeals Board case, that even upon appeal, the Supreme Court declined to address. It is still very clear that a public safety officer has to, of course, be a public safety officer. They have to demonstrate known exposures to known carcinogens, and they have to show that the cancer so developed while they were employed. So it's not that you are granting a presumption or extending a presumption that was granted in current law because we said so. There has to be a demonstrable link between our exposures and the cancer that we've contracted. For these reasons, we ask for your support, Mr. Co-author and members of the committee.
We appreciate those comments. Mr. Perry.
Mr. Chairman, members, Randy Perry there and Reed & Associates on behalf of PORAC and our CDF firefighters and High Patrol. In the interest of time, I just want to remind everyone that this is still a rebuttable presumption. And as Christy Baumann mentioned, we have to still, at any time, even in a rebuttable presumption, generally the rule is they file a rebuttal. And so then we take it from there and we battle it out and work on the issue. So I just want to remind you that during that rebuttal, we still have to show that it's related. We still have to show generally instances, and that's how we end up winning those when we do. And we lose them if we can't. So I just want to remind the committee of that.
Appreciate those comments.
Mr. Chair, members, Caitlin Vega for the California Labor Federation, also here in support.
Mr. Chair, Deanna Furman on behalf of the California Nurses Association, also in support.
Thank you, Deanna. Opposition. Are you in opposition representing someone else?
Uh-oh. Oh, here we go. That's the type of reception I like.
There are worse ones than uh-oh.
Right. I'm gonna be the villain again. It was said that in order for these cases to be successful, that they have to demonstrate the link between the cancer and et cetera. And that's actually not quite true. What you need to do is claim cancer and show that there was an exposure to a carcinogen. It doesn't have to be the carcinogen that would cause that cancer or whatnot. What the presumption means is that the burden of proof now falls on the employer. And there's a recent case that is very telling. We've come in for years and say these are very hard to overcome, the presumptions. In this case, I think we'll demonstrate, and I'll send it to your staff. I actually failed to do so already. In this case, an AME said there is no industrial causation for this cancer. And his reasoning was that this person had exposure outside of the workplace, and there were no studies that linked the specific exposure in the workplace to the type of cancer that person had. So the agreed medical evaluator, typically a very moderate force in the workers' compensation system, did something unusual and said, no industrial causation. What the judge did is then come back and said, that's not good enough. Simply showing that no evidence exists to link that specific carcinogen to the type of cancer isn't good enough. What you need is a study that shows that that specific carcinogen does not and cannot ever produce that type of cancer. And the AME, when he was deposed, said a very interesting thing. He said, the law and science are inconsistent. Science, medical science, does not produce this type of report. What that tells me is in this context, it is nearly impossible to overcome these presumptions. So while this bill may not be expanding dramatically, and the bill was scaled back in the Appropriations Committee in the other house, and we recognize that, but there is still this burden of proof. And if we want to have a conversation about whether presumptions are right or wrong, that's fine. But we need to get to a point where if the presumption is rebuttable in the statute, that it's also rebuttable in practice. And if medical science does not blend with the law, we need to look at changing the law. So with those comments, we would ask you to vote no.
Irene Ortega, California State Association of Counties. We're also opposed to the bill. We do believe this creates an unknown additional liability. This is not to say that these cases where it is work-related would not be compensated. It's the issue of the presumption and this expanded liability. So for that reason, we ask your no vote.
Julianne Broyles here on behalf of the California Association of Joint Powers Authorities, also in opposition.
Mr. Chair, members of the committee, Michael Corbett, representing the CSAC Excess Insurance Authority, in opposition.
Mr. Chair, Steve Kawamura on behalf of the Board of Supervisors, Los Angeles County, in opposition.
Natasha Carr on behalf of the League of California Cities, also in opposition.
Iris Herrera with the California Special Districts Association, also in opposition.
Hugh Bauer on behalf of the cities of Santa Rosa and San Marcos, in opposition.
Mr. Chairman, members, David Wolf here with the Howard Jarvis Taxpayers Association. We're opposed.
Thank you, Dave.
And Mark Brigade on behalf of the California Chamber of Commerce, also opposed.
Mr. Cotto, would you or your sponsor like to address some of the concerns that have been brought up?
I think sponsor would like to address it.
Mr. Chair, just to maybe correct the record, because we're into doing that today, I think Mr. Smelter and I are quoting from the exact same court case, which is a delight for me, which is that the judge said to the medical examiner, because his reason for denying the cancer case was because he was not aware of a study that directly linked this form of cancer to firefighting. So what he rejected was that the presumption that there was no study didn't mean there wasn't a link. That is actually what the case before us identified.
And she mentioned you by name.
Thank you. I do love being mentioned by name.
Mr. Perry, you haven't been mentioned by name other than by name. So sit down.
I don't fault the judge in the way that he applied the law in this case. Basically, he did something that employers do quite a bit when they look at medical reports. They say, does this constitute substantial evidence? And in this case, he found that it did not. And the reason is, like I said, that medical science doesn't meet up with the requirements in the law. You, as an employer, have to prove that there is no possible link. Simply having other facts that show that there is another likely link and then no medical evidence to support the link that is being claimed is not enough. I will send the case to your staff, and then I suppose we can debate it more.
Thank you. Appreciate it. Do you have any closing comments?
Well, other than ask for your vote, I think this is a modest approach. We've scaled it back down, and it does offer our firefighters and our public safety officers who risk their lives on a daily basis, are exposed to all kinds of toxics, that this is the least we could do, and I would respectfully ask for your vote.
Before you leave, there's been some changes, at least I believe in the other House, in approach as to the cost. And given the concerns about costs to local government, do you have any idea what the cost might actually be? I think approach was fairly modest to the cost because it's I assume, fairly small group of individuals, and then it went to a much higher cost, and if memory serves me, $200 million.
Was that, go ahead.
Mr. Chair, the initial analysis on a bill from last year that had no cap was tagged with a $300 million cost. The initial approach analysis took it down to $200 million, from going from 30 years to 5. So the number's mysterious to us. The only data that we can provide, since we are not the employers, is the data that we get from the Commission on Health and Safety and Workers' Compensation. And they said under the current presumption, the current status of the law, there are on average about 20 cancer claims a year. Did not indicate whether they adjudicated one way or the other, but there were only about 20 a year for firefighters.
So adding 5 more years is not going to change exponentially.
The connection between 20 cases and $200 million is a complete mystery to us.
Okay. Thank you. Thank you. Let's see. Mr. Davis. Mr. Davis, you have item number 7, AB 2032.
Yes, sir, Mr. Chairman.
It's nice to see you.
Thank you.
notice you have a Lakers poster on your doors.
I hope so. I hope so. We are glad
Being
to
a
have
Boston fan, you have no fear here.
That's right. Thank you, Mr. Chairman. We appreciate that. I'm here to present 2032, which gives needed protection to children working in the entertainment industry. The Division of Labor Standards Enforcement is to ensure, the purpose of the division is to ensure employees do not work under unlawful conditions. Current law requires that DLSE should issue an entertainment work permit to children employed in the performing arts. Surprisingly, once in the entertainment entertainment permit is issued, no one from the state ever checks on the physical and financial well-being of child performers. AB 2032 will remedy this situation by requiring DLSE to enforce the existing permit requirements, for instance, by making unannounced visits to the workplace of child performers in order to check that the performer's paperwork is in order and that the workplace is safe. Amendments AB 2032 was amended in the Assembly to remove mandatory fee for the Children's Entertainment Work Permit. The bill is supported by Working Actors and Screen Actors Guild. There is no opposition, and I respectfully ask for your aye vote.
Witnesses in support.
Tim Lynch on behalf of the Screen Actors Guild. This bill came to light about a year and a half ago when the governor proposed to shift some of the duties at labor down to the school district level, which we found to be a totally unworkable solution. We think this bill is a great step in the right direction, and with the fee authority established under it, will create a safer workplace for working children.
Any other comments? Any other witnesses in support? Any witnesses in opposition? Mr. Davis, would you like to close, and maybe as part of your close, just how you expect to get a signature on this bill?
Well, this bill will help make workplace safe for entertainment workers who happen to be children in the state of California. We believe very strongly that this is good public policy for those children and that the governor will objectively consider this bill this time.
Thank you, Mr. Davis. Well, we'll call for a roll as soon as we get a quorum back.
Thank you.
The chair is supportive.
Thank you, sir.
Let's see. It's a miracle. We don't have any authors. Maybe they thought we were never going to get to them. Well, in file item order, we'll take whoever appears, but we have Mr. Delatorre, Mr. DeLeon, Mr. Emerson, Mr. Swanson, Ms. Skinner, Mr. Portantino, and Mr. Solario. Mr. Perry, would you like to present all of the bills?
Solario just said he's on as well.
Okay.
Sounds like they got something.
Mr. Solario, I've been thinking of you because all the bills that are on call have a notation by me, just OC. So, on behalf of the OC, welcome.
Thank you, Chair and members. I know you've had a long day. Luckily, I do have a very simple bill. It says that a public agency can extend the amount of time off with pay that an injured public safety officer may receive. It would be 100% at the discretion of the public agency. As the analysis notes, it's possible that some employing agencies may already have these type of arrangements, but they're very few, and we'd like to put in statute so it can be available to more injured public safety officers. Again, this is entirely voluntary, based on the part of the agencies and the injured workers, and I ask for your aye vote.
This is in support.
Mr. Chairman, members, PORAC sponsored this bill. The opposition argues that current law allows them to set up these contracts, if you will, with the employees to extend any benefits. However, we have heard from several of our members that the employer is questioning whether this extends to 4850, whether it extends to these benefits. We're simply just trying to clarify. We want to amend the section to say that through collective bargaining, the employer and employee can come to an agreement to extend a benefit if the employee's injury should take them beyond the 12 months. And there are very few cases that this ever occurs to, and just allows them to bargain for it. And that's it.
Mr. Chairman, Christy Baumer representing the California Professional Firefighters in support.
Okay. Other witnesses in support? Other witnesses in opposition?
Good afternoon, Mr. Chairman. I'm Julie Broyles here on behalf of the California Association of Joint Powers Authority, regretfully in opposition to AB 2397. The bill, as it is currently written, creates a number of problems for public entities. The Joint Powers Association, of course, provides insurance coverage for school districts and cities and counties for their public safety officers. 28397 proposes to add a very new complex level of costs and duties to California public employers. Under this scenario, and I'd like to point out today, chief disease is a problem that we battle in the public sector, where people go out on disability leave at the age 49 and then take off a year at 48, using 4850 pay, and then retire anyway. Under 2397, that adds a whole new layer of costs if it's mutually again agreed to between the employer and the officer. That would add we went to one of our local cities and asked what it would do to them, and they said under 2397 they would be off for 2 years on the labor code 4850 pay. It would then be followed by 2 years of workers' comp temporary disability benefits at $51,000 a year for a 4-year total outlay of about close to $300,000. That would raise the cost for that one officer's being off for that extra year by about $100,000. Additionally, our CBAs prohibit us from filling that officer's positions, so we have to turn to other officers to cover that position while they're out on the 4850 pay. If you can do this underneath your CBA, that's fine. But again, you're going to set a new floor for public employers. If you have a number of agencies working with their officers to provide this kind of pay, then you're going to have it as a new floor, and they would not have to give any concessions when dealing with the public sector employer to get that particular benefit. We think this is a big problem. We don't think it should go forward, particularly when we're already cutting staff, laying off people, and we already have straitened budgets. It's not the time to do it. Ask for no vote.
The question, just while I have you here, the question Mr. Perry brought up that it was clarifying that they already had the authority. So that the question would be, would they have if they have the authority now, they could already be doing this.
If they have the authority today, then they wouldn't be here asking for the statutory permission to do so. We don't believe they have this authority and would ask for the no vote.
So in your mind, eyes, it's not a question of ambiguity. You don't believe you have the authority and you don't want the authority.
Correct.
Okay. Mr. Perry, would you respond to that? Because I was under the impression this was purely clarifying existing.
Well, there was a long line when this was in Assembly Insurance opposing it, and then actually as we amended the bill, everyone kind of agreed that this is clarifying. In terms of, again, I just remind the opposition that this is negotiable. I mean, if a city says that, if we allow this up to a certain period of time, that they would have to pay extra, well, then they don't negotiate and don't grant it. Also, to make a statement that at the table you don't have to give up any concessions to get it, I would argue that you would likely have to give up concessions to get something like this. So it's all bargainable. That's all we ask, is to be able to bargain for it.
And I agree with that. I just, we have local government agencies now who have the ability to bargain on other issues, now coming to us going, don't give us the ability to bargain. So it's just an interesting, I'm thinking of particularly pensions. They did it. They bargained. Usually it's in the case of management and given them benefits that are pensionable that have become headline stories, unfortunately. So it's just an interesting discussion to have.
And the key on this is it's not a mandate. We're authorizing, locals to do this, and, injured workers have, been hurt on the job. They're important employees, and on a case-by-case basis, cities can look at whether this makes sense for them or not. That's why I ask for your vote.
And the point is that they are still injured.
Correct.
And they have to go through that criteria. Okay. I will support the bill, but it's an interesting discussion.
Thank you.
Thank you. Again, we're looking for authors. So Mr. Delatorre is next on the sign-up list. Then he's followed by Mr. DeLeon, Emerson, Swanson, Skinner, and Portantino. all of a sudden we have a gaggle of authors and would-be authors. Mr. Port. Mr. Emerson, you're next in the queue. And since you're a much esteemed colleague now, as opposed to...
Thank you, Mr. Chair. I guess that's it.
This happens to me when I go out, too. I sit down and everybody leaves.
You
probably experience the same thing. Yeah. Mr. Emerson, speaking of going out, meal periods.
Yes, thank you. AB 569 will allow employees in the transportation, construction, and security industries and employees of electrical and gas corporations that are collectively bargained to follow the terms of their collective bargaining agreements as it relates to meal and rest periods. It is important that certain industries have the flexibility to negotiate their meal periods, and this measure provides them this ability. As you know, this is a complex and serious issue that UPS has tried to fix since 2003. I would like to expand this measure to others, but I believe it's time for AB 569 to be a step in the right direction. I respectfully ask for your aye vote.
Mr. Emerson, we have a tradition, perhaps you haven't heard about the Senate, that when you come over as a senator, you have to read your statement on your first bill in front of the committee backwards after you read it forwards.
Not a problem.
I knew for you it wouldn't be in your Yoda-like wisdom. Witnesses in support.
Mr. Chairman, Bo Biller with Platinum Advisors on behalf of UPS. We're the sponsor of this measure, and I would like to, for those within earshot that aren't here right now, thank Senator Wyland, Senators Ducheney, Hollingsworth, Leno, and Yee for all supporting this measure. The last time we were before you, it's a little bit more expansive this go, but very similar, and we appreciate your support again.
Mr. Chair, Phil Vermeulen representing the engineering contractors in strong support. Urge your aye vote.
Other witnesses in support? Witnesses in opposition?
Mr. Chair, members, Deanna Furman on behalf of the California Nurses Association. CNA opposes any changes to the current law surrounding meals and breaks, including changes that would allow on-duty meal periods for workers covered under collective bargaining agreements. In the current environment, RNs struggle to take meals and breaks because of the nature of their work. We believe that this bill creates a slippery slope and that other industries will seek similar exemptions. Many of our most contentious contract negotiations and strike votes have been around this very issue about meals and breaks, because with improper meals and breaks, it results in inadequate and improper staffing of the legally mandated nurse-to-patient ratios. So for all of these reasons, we believe that workers are best supported with the current law, and we remain opposed to this bill. Thank you.
Thank you, Mr. Chair. Dawn Kepke with McEwen Associates on behalf of the California Manufacturers and Technology Association. And we are in an opposed unless amended position. While we understand the proponents' interest in the relief that would be provided by this bill, we really are strongly in the position of feeling that this relief should be extended to all employers and all employees in terms of flexibility for meal period rules. We support a comprehensive solution that will protect employees and appropriately regulate employers. We just feel that providing such relief for just a select few industries is unfair. That said, we are continuing to be willing to work with stakeholders and the Assemblyman, Senator, to work to craft a solution that works for everyone. Hard for us to say, too. So we are committed to continuing to work with the author and stakeholders, but at this time must remain opposed.
Appreciate it. Mr. Chair, David Vandergriff of the California Hospital Association regretfully must oppose the bill unless it's amended to be a comprehensive fix. Thank you.
Steve Pingle on behalf of the California Employment Lawyers Association, and similarly to our concerns on AB 2340, we believe there are safety issues in exempting these specific people, commercial drivers, security officers. Hunger fatigue can affect their judgment, their emotions, etc. This is not the industry to do this with. We don't think that the bill anybody else should be carved out, and we think that the right to take a timely and healthy meal break or lunch break is essential for not just the workers but for all of us. And we urge a no vote.
Julianne Broyles here on behalf of the Association of can't even talk this afternoon. Sorry, it's been here too long. The Associated Builders and Contractors of California, regretfully in opposition to the senator's bill. We think again that this is a problem for every type of employer. You shouldn't be doing special carve-outs for particular industries. Dealing with this once and for all employers is the best policy. It will reduce the number of lawsuits here in the state that are continually being filed, and certainly encourage employers to think more positively of growing their employee populations here in the state. So with deep regrets, we're opposing the bill.
Thank you. Any closing comments, Senator?
No, I just asked for an aye vote. Thank you.
Okay, well, we will take it up when we get a quorum back, and I am an aye vote on it, and I appreciate all your hard work in this regard. Appreciate the opponents' comments, too. It would be nice to get a complete fix, and I know you would like to do that as well, but our failure
absolutely.
to do that has us here today. So,
all right. Thank you very much.
Well done. Mr. Delatorre, welcome. AB 2055, item number 8.
Thank you, Mr. Chair. AB 2055 will ensure that same-sex couples in California are not denied their right to unemployment benefits, while married couples, those soon to be married, and registered domestic partners are eligible for unemployment benefits if his or her partner moves for employment. Those who are soon to become registered domestic partners are not. As defined, this term spouse includes individuals, couples, and couples where marriage is imminent. However, the law does not cover imminent domestic partners. This is just a simple equality issue. Here to testify is Mario Guerrero from Equality California.
Welcome.
Thank you. My name is Mario Guerrero, and I'm Government Affairs Director for Equality California. Equality California is the sponsor of AB 2055, and I would just add that AB 2055 is necessary to ensure that the state of California fulfills its constitutional mandate to treat same-sex couples, same-sex and different-sex couples equally. Enacting this measure will bring California into compliance with the law and thus will preclude any need for costly litigation. And in addition, it'll bring us one step closer to equality. So we respectfully ask for your aye vote.
Thank you. Any other witnesses in support?
Mary Weiberg, Commission on the Status of Women. The Commission is in full support of this bill.
Thank you, Mary.
Mr. Chair, Seth Bramble on behalf of the California Teachers Association in support of this important legislation.
Well done, Seth. Any witnesses in opposition? Seeing none, would you like to close, Mr. Delatorre?
I ask for your aye vote.
You will get it when the time comes. Thank you for this important piece of legislation.
Thank you very much.
Mr. Swanson? I should say, Mr. Chairman.
Thank you, Mr. Chairman.
You got item number 25, AB
Yes.
2774.
Mr. Chairman, thank you so much. AB 2774. At the outset, let me say that this bill continues to be a work in progress, and we are making progress. The bill was introduced in response to concerns raised by the federal OSHA regarding the issuance of serious citations by Cal OSHA. In particular, concerns have been raised over the lack of definition in the statute for serious physical harm. Under current law, in order for an OSHA violation to be classified as serious, it must be shown that there is substantial probability of serious harm. We have been negotiating with the employer community throughout this process and have had good discussions, but have not reached a final agreement. Just last week, we convened a meeting of stakeholders in order to try to facilitate discussions on this issue. It was a productive meeting. The administration indicated that some language would be forthcoming for the parties to consider in looking at this issue. Parties are scheduled to reconvene on July 1st for further discussions. Therefore, in the meantime, I'm asking for your support in moving this vehicle forward as we continue the negotiations. And I have my witness self-introduce.
Mr. Chair, members of the committee, Jeremy Smith here on behalf of the State Building and Construction Trades Council. I'd like to thank the staff for a very good analysis as to where we are on this bill and what's transpired so far. We're here for a few reasons, one of which is FedOSHA says we have to be here. We've got to do something to fix the fact that there is no definition of serious physical harm in statute, and the way that the appeals board adjudicates its cases or gives direction to their ALJs. It's created a disincentive for Cal OSHA inspectors to even bring serious citations to the appeals board. The numbers bear this out. 19% of citations in California are serious. 43% in other state plans are serious. And the FedOSHA, 77% of their citations are serious. So there's a real numbers gap there that we need to fill for real reasons. There are workplaces that remain unsafe because of the way the appeals board does their business and because of the way that they've decided to decide what constitutes serious physical harm. They've also held themselves to not be made or to follow directors' regulations. So we need to do a bill to make them do what we need them to do, and they've actually asked for a bill. So that's why we're here. We're having very good conversations with the business community, and that now the labor agency, we're happy they've joined in. And I think we're going to get somewhere, but we need to keep the bill moving forward so when we do get somewhere, we have a vehicle to put the language into. Thanks. We hope you can support.
Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. We think that defining serious physical harm is important toward protecting workers from some of the most egregious kinds of accidents and injuries. And we also think that it benefits employers having clarity. So we think this is a win-win and an important bill.
Thank you. Any other witnesses in support?
I should add that applicant attorneys wanted me to say they're also here in support. Doug Kim had to leave, but he wanted me to make sure that I said that for him on his behalf. So
nice to see that your two organizations are supporting a bill.
Only in 2 hours after we weren't, right? So here we are.
We should take this bill first. All right. Speakers in opposition. You're earning your pay today. Take a meal and rest period.
Where is that in the Labor Code? Julianne Broyles here on behalf of the California Association of Joint Powers Authority and the Associated Builders and Contractors of California. We have several concerns about this particular bill. First of all, this bill is premised on an initial statement offered by the Federal Occupational Safety and Health Appeals Board on an initial review of a problem of whether or not there might be a problem with the definition. All of that goes to the point of that they are not finished with their review. They have not concluded that this is the best approach. And we are now taking up statutes in advance of that report, not due until the end of this year, as noted in the analysis, which was very thorough. And again, we appreciate that very much about the bill. And so when you put in statute in advance of a conclusion, you end up again with the possibility of putting California's state plan out of conformity with what a federal plan might require. We don't think this is the time to do this. I worked with Senator Steinberg on AB 1127 when it went through the legislative process. The issue of what a serious injury is was a subject of deep discussion, both with his staff and with some of the stakeholders that are here today. And we were very careful again at that point to try to match to what was done at the federal level. I have checked with some of the Cal OSHA Standards Board members. They don't think this is the appropriate way to go about this. There is a process to change what the definition is, not through the Appeals Board, but through the Cal OSHA Standards Board. That has not been approached. I understand that there is a meeting coming up this next week that I hope to be a part of to talk about this further, but we think this is a very far in advance of a true solution to what may or may not be a problem, and for that reason you're asking that the bill be held here until those discussions are complete.
Chairman, Bruce Wick, California Professional Association of Specialty Contractors. I'm the risk manager. As Chairman Swanson said, this has been a great dialogue, and as Jeremy Smith said, a great dialogue. We appreciate all that we've done. But it is important to get this issue right. As Julie said, serious violations in California are extremely expensive compared to other states. Those do go on your permanent record. We just got rid of a major backlog at Cal OSHA Appeals Board, And both labor and management, everybody agrees it'd be really a bad thing if we ever got back there again, and employers appealing in excess of serious citations would be difficult. The way that the bill is currently configured only allows 3 days for an employee to have an impairment, and it's the timeline of impairment that's our real difficulty. Conservative medical treatment, the good employers understand, is a really important thing. You know, we don't send people back into construction. Maybe the doctor releases them. We give them time off for the body to be really ready to go back and do that job. And this bill just cuts that time too short, and those things shouldn't be in opposition to each other. So there are many reasons why we have this issue with federal OSHA and Sirius. This is only one facet of it. So we appreciate the dialogue, and it's just really important to get this right. Thank you.
Thank you.
Mark Brigade on behalf of the California Chamber of Commerce. For the reasons previously stated, we oppose the bill, and we do appreciate Ms. Vega's comments trying to make things more clear for the employer community. But based on the current language of the bill, we still oppose.
Appreciate that.
Ellie McKechnie on behalf of Western Growers. Just echo the statements of my colleagues and in opposition. Thank you.
Great. Mr. Swanson, maybe you could address some of the comments by the opponents in your close.
Well, thank you. I would say that we're in a situation where the option of doing nothing does not exist. And we have shown a great deal of good faith by holding the discussions, and we have gone forward with making adjustments to the bill in response to reasonable objections. And so but the issue of serious physical harm has to be codified into very specific language so that we can address this question as a matter under the authority of OSHA. I don't know. Did you want to add anything to that? Or, okay. Then, and so I would just say I'm asking that the bill be allowed to go forward so we can continue the discussions. The next one is scheduled for, I think, July 1, and we have been negotiating in good faith, and we are prepared to modify the bill if we reach very specific arrangements as we go forward.
And part of those discussions is being consistent with whatever their federal definitions would be.
The federal definition, and we've been asked to do that.
Okay, thank you.
Not an option.
Do we have any questions or comments, or perhaps a motion? Okay, we will move it on. There's a motion. I ask the Secretary to call the roll, please.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, Duchesne, Hollingsworth, Leno? Aye. Leno, aye. Yee.
Thank you, Mr. Swanson. It's on call. You need 2 more votes.
Thank you very much.
Mr. Portantino. Two of the most charming members of the legislature back to back.
He says that's all.
I was going to say,
Actually, no, but it was delivered with a smirk, so.
He was a restaurateur, right?
Right. Was.
Thank you, Mr. Chair and
Speaking
members.
Of temporary workers.
AB 179 seeks to correct an unintended consequence of previous legislation that resulted in costly administrative burden to hospice, home health, and home health care agencies. The previous legislation required temporary service employers, as broadly defined, to pay their temporary employers weekly. AB 179 would simply exempt hospice, home health, and home care agencies from this requirement, allowing employees in these important sectors to be paid every other week. The original legislation, I believe, was not intended to impact these industries, and hopefully this bill can correct what I think was an oversight by the legislature. Without this exemption, the cost of care in California for seniors, people with disabilities, and others in need of home care will rise due to an unnecessary administrative burden. And it's not my intent to not pay workers in a timely manner, but to correspond to the pay schedules of those programs and not have to have them create a different administrative option for pay. So that was the intent, and I have representatives here who would testify on my behalf, Mr. Kellison and Mr. Lindsay.
Thank you, Mr. Chair and members and staff. Jordan Lindsay with the California Association for Health Services at Home. First, I just want to thank the committee and staff on both the Senate and Assembly sides for helping us with this issue. Previous legislation, SB 940, never intended to include home care or hospice or home health in its definition of temporary services employers. That was an idea where temp staffing agencies would have to pay weekly, but when their clients are big companies where they're sending staff to, our clients are 90-year-old women in their homes, families with children with tracheostomies, a person at the end of life. That's our clients. And so unfortunately, under the definition of temporary services employers, we were included under that unintentionally. Now we have to pay weekly. What's the big issue about that? Well, the big deal is that home care companies, a huge amount of our overhead administrative costs is just payroll. And so now all of a sudden we're increasing our costs tremendously for no real big benefit. And so this is actually an issue about cost of care for seniors and people with disabilities. There has never been an issue about paying every other week, which is industry standard and was what the industry was doing 2 years ago before SB 940. There was never any issue that came to our attention or our members' attention. So we would just like to take it back to pre-SB 940, allowed to pay every other week, so we don't have to have the costly, double the cost of payroll. And in this painful economic time where through our budget issues we're having to cut consumer services, having to cut provider rates, we're trying to find any way we can to provide some type of relief. This is a no-brainer. There's no benefit to paying weekly. We haven't seen that there's any need for it. And this just creates an easy relief to reduce costs of care for seniors and people with disabilities. Thank you.
Mr. Ellison.
Peter Kellison on behalf of the California Hospice and Palliative Care Association. Workers that work for the hospice programs in California, there's about 300 hospice programs. They're not temporary workers, they're full-time employees, but by the nature of their assignments and going into the homes or hospitals or SNFs to care for the terminally ill, they are defined as working on temporary assignments. People who work in these programs are not doing it because it's a job. They're working for hospice programs out of a labor of love or out of a commitment. We support the bill. We think that we're paying them on a semi-monthly basis makes sense, as that is the industry standard prior, and looking for support.
Okay. Other witnesses in support? Naylor.
Mr. Chairman. Yeah. Bob Naylor, representing Addus Healthcare. We supply in-home supportive services under contract with 5 California counties and in a dozen other states. Our client is actually the counties, but because of the way the original legislation is worded, we are at risk if one of the IHSS recipients decides for various reasons not to keep the worker for more than 90 days, even though our intent in hiring is at the beginning is always as a permanent worker. This represents a big penalty problem, and complying represents a big cost. We support the bill.
Thank you, Mr. Naylor. Witnesses in opposition.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. I will try to be brief because of the hour, but this is an issue that we've worked on for several years. After the Smith v. L'Oreal decision about 3 years ago, the temp industry approached labor and basically said, we have a crisis. There's a California Supreme Court decision which is going to require us to pay all temp workers immediately upon the end of every assignment, and this is going to destroy our industry, and we need a bill to address it. We vetted with our unions, and on the natural, our unions come at this from a position of wanting to support full-time permanent employment. We don't necessarily like the role of the temp industry, and we don't necessarily like the transition that is going on in our economy to an increased reliance on temporary workers who have far fewer rights, tend to be paid less, and have a lot less worker protections. Nevertheless, we took the problem seriously. We engaged in many months of negotiations that Senator Yee convened, and we were able to finally come to a compromise. That compromise was, as long as there is weekly pay, we will agree to basically give you protection from the idea that you have to pay upon the end of every assignment. This was a very hard thing for labor to come to, because as I've said, many of our unions have battled with temp agencies within their specific industries, the use of temp workers to break strikes and to undermine working conditions. But we thought that that was a reasonable and responsible compromise. In the last couple years, numerous industries have come to us and said, it's impossible for us to comply. This is too great a burden. Our work is too important. Every time we've said, look, this was the compromise.